appeals, my lord, tomorrow, my lord.
What is the urgency, sir?
My lord, pursuant to dismissal of the writ petitions, my lord, the authorities have issued new NITs, my lord.
Okay, when was the writ dismissed?
My lord, it was dismissed on 7th of February, my lord, and we have filed it on 3/3/2023, my lord.
Okay. Get it listed on Thursday.
Very please, Lordship. Lordship, I beg to mention item number 10, Lordship.
Yes,
In item number 10, we are appealing for the respondent.
yes.
The learned counsel who is appealing for the respondent is having some illness today. For today, I have taken the consent of other side, Lordship.
The other side,
Yes, my lord.
likhiye, then counsel Shri so and so appearing on behalf of so and so. Please for time. The petitioner's counsel does not have objection. List up to 3 weeks,
1 week, my lord.
1 week.
Yes, my lord.
Okay.
Obliged.
May I please, your lordship? The listing of writ appeal, lordship, on 17th of March, lordship. It relates
What is
to
the matter about?
lordship,
The impugned order is dated. What is the date of the impugned order?
impel order last listed on 31/23, lordship.
The single bench order, what is the date of that
I have
order?
not remembered, lordship. Single bench. I have one, my senior will appear, lordship. I
Okay, you also get it listed on Thursday.
oblige, lordship.
May I please, your lordship. Your lordship, I want to mention a PIL which was filed today morning. The filing number is 2939 of 2023. Lordship, this matter essentially pertains to several illegalities and irregularities which have been committed by the Education Department of the state of Assam in awarding certain works under a tender to certain private players. Your lordships, in particular, the work order has been issued, payments have been released despite several instructions from the central government to the state government requesting the latter to investigate the matter and report back to the center. In particular, your lordships, we are talking about 342 crores worth of public money, which in my humble submission is getting misappropriated by these private players in connivance with the state authorities. Therefore, it is my humble submission that your lordships will find it appropriate to list this matter as soon as possible on Wednesday or on Friday, your lordships.
All right, get it listed on Wednesday.
Much obliged, your lordships.
With the consent of the other side, your lordship on the 3rd of March had transferred matters relating to the constitutional validity of an office memorandum regarding reservation in promotion.
Mhm.
Under these two matters on that day, we could not give these numbers with your lordship.
They were transferred.
They were transferred to a division bench because we had challenged the constitutional validity of certain clauses, taken away our rights.
Okay. Get it listed. When do you want the
Although
listing?
these matters were listed before the single judge on the 16th.
Right.
So your lordship will give an appropriate date.
So, but they,
Because the other matters are also coming on the 16th, 17th.
this very month.
Yes.
Okay, very well. Get listed on 16th then.
Yes.
March. Yeah, 16th March. Yes.
Item number 1 of daily list.
Mr. Saikia, you were supposed to
Yes,
respond.
Lordship, I have obtained instruction.
Yes.
Initially, the thought process was that the medical college and hospital will be constructed within the town area along with the civil hospital.
Mhm.
Later on, it was found that the area which was available along adjacent to the civil hospital is not sufficient to have a
Okay.
full-fledged hospital plus the college.
Right.
So therefore, 150 bigha land was found out, which is about 50 kilometers away. And
50.
50. 5 or 15, sorry, 15 lordship. 15 kilometers away. And now here 150 bighas land, out of which 114 bighas land will be used for medical college and hospital. And 36 bighas of the land will be used for a sports complex along with that same area.
Okay.
By this way, there are two benefits. One is that a new area will be developed, which have completely
Is it
free,
connected?
well
by the-
connected. And number two, the civil hospital will remain as a civil hospital.
Of course, that will remain. So what is the status of the approach to this land which has been now identified?
There are easy access, lordship. If something is required to be done also, it will be done. That there is no difficulty on that.
So
All this,
Chaudhary, what do you say?
My lord, it is not 15 kilometer, my lord. It is more than 50 kilometer to my, as per my instruction.
Do we have the exact location on record?
I can bring it, lordship.
No, the petitioners must have placed
But it is
it.
within the district.
My lord, as I told the other day, it is in another constituency and it is more than 54 kilometers, my lord.
Constituency.
And as
doesn't
per the
matter.
government instruction, my lord,
Mhm.
it has to be within 10 kilometers. And
Which is-
land was identified.
They say that the land is not sufficient.
No, my lord, there is nothing like it.
We can never have a small piece of land for
No,
a
my lord.
hospital, sir.
My lord will
Let
kindly
us see
come,
the initial proposal.
my lord will kindly come to page 30. This is the land which was identified.
Let us see.
Yes, my
140
lord, the
bighas.
circle officer is writing to the deputy commissioner. With reference to the subject cited above, I have the honor to state that the land having total area of 140 biga, 6 hatak land of Moja Umarpur was identified for construction of medical college at Karimganj, out of which 126 14 katha 3 chatak is Pata land and 13 biga 6 katak 3 chatak is government khas land.
Right.
As the land is having an area of 126 biga 14 kata, land is patta and hence compensation of the aforesaid patta land required to be paid to the patadar of the aforesaid laid for construction of medical college at Karimganj as per the zonal value, etc., etc.
Right.
This was the land asked to be identified. There's no question of being insufficient land.
Patta should land, sir.
Yes.
It's the process of acquisition.
Yes.
How long would it take? What is the status of the land now?
Now it
identified?
is, mostly it is government land.
No, I think let
That
my land
compare-
have that instruction. my
Let
lord.
that come on an affidavit.
Yes, Lord.
Yes.
Okay. Then Advocate General, Sri Saikia submits that the major portion of the land now identified by communication,
No, Lordship, I have just telephonic.
now identified for construction of the fresh location of land identified for construction of the medical college associated with a sports facility comprises of a major share of government land and a small part thereof is Patta land.
I'm
This-
not sure about whether it is Patta because mostly it is government land.
Government land तक ही रखिएगा. He further submits that the relevant parameters have been taken into consideration for identifying the fresh chunk of land which is compliant of all statutory and regulatory requirements. He prays for and is granted short opportunity of 7 days to bring on record these facts through an affidavit.
Deeply obliged.
We'll have 2 medical facilities this way. Let the earlier one not be extinguished.
Deeply obliged.
We did this exercise in Rajasthan. There was a district, there was a CHC in a town called Pipad. So the earlier proposal was to construct a district level hospital on the same portion. The PIL came in. So we said that, why are you worried? You will have 2 facilities within a distance of 6-8 kilometers. So the directions were given to construct it on the new site immediately while upgrading the earlier facility.
My lord, we know our limitation on this side, my lord. We are trying only. my
No,
lord.
it's okay. But this is definitely a
Certain.
better proposition to upgrade the existing facility and have an additional facility.
New one.
That's always better. Yeah.
Deeply obliged.
Thank you.
Item number 2,
Date दे दीजिएगा. List on. Mr. Saikia, when will you be able to file the
2
affidavit?
weeks time may be given, Lordship.
Weeks time. 21st,
Lordship.
21st.
May I please, your lordship? By way of the present petition, your lordship, the petitioner has put to Chennai the notification, your lordship, by which your lordship, the district of Bishwanath Sariali, your lordship, of which the present petitioner is a resident, your lordship, was sought to be merged with your lordship, its original district of undivided district of Sonitpur, your lordship. Now, your lordship, in fact, what has happened, your lordship, on 25/1/2016, this district was created after your lordship long standing demand of the citizens of that particular district, your lordship. And along with these, your lordship, 5 other districts were created, your lordship. And on 25/6/2018, your lordship, there is an upgradation and district hospital was, your lordship, upgraded and construction was going on, your lordship. And on 10/12/2020, your lordship, foundation stone for the new integrated DC office has also been, your lordship, laid, your lordship. And thereafter,
Where
what
is that,
happened?
where is that document? You are referring to Commissioner's office?
That is, your lordship, I have annexed and page 39, your lordship,
Yes.
a report, your lordship. By-
News report.
That's, your lordship, has, this has, in fact, has happened, your lordship. This was, your lordship,
But
enumerated,
this report doesn't refer to the foundation stone of the DC office.
page
sir.
40, your lordship.
Yes. Hmm.
It may be noted in that in Vishwanath, the foundations
Mr.
that have
Saikia?
been.
We need to respond.
We will respond.
We'll
Lordship,
formally issue a
because of
notice,
administrative
issue
reason.
notice
This-
to the respondents.
This is in December. Suppose in December, we laid the
What is the
foundation.
reason? What is the reason that a district which was created 5 years,
Yes,
6, 7 years back, why it is being reintegrated into the earlier district?
There are various administrative reasons. That is one major issue, Lordship. And therefore, just
Then
before
we can
this,
presume,
the
Saikia-
delimitation exercise started, Lordship, there was a direction that we cannot change anything. So on 31st, we issued the impugn order. It is not final. We are again bringing it back to the earlier stage. Everything will go on, Lordship, and in future, if there is a requirement of having and bringing it back to the original status of a new district, it will
why
be
the
brought.
state of flux? It was a notification issued way back in 2016. And creation of a new district brings in so many avenues of development. Why do we want to go back and then selective decision? Selective, because there were 5 districts at that point of time which were created. Why only Vishwanath is?
No, all
Retracted.
districts were now amalgamated to
Not-
the original
not-
question. Not only this.
Not.
There is
all.
another.
Not
We
all.
have changed several districts, like Hojai was a district, Hojai was again brought back to Nagaon. Identically, one district in Bojali. it has
Like,
been-
why this uncertainty?
No, certainty
what
is there,
is the
Lord.
reason
Certainty
behind it?
is there, Lordship. There is some overwhelming public interest involved.
All right, you bring these facts on a
Lord.
record on affidavit. Issue notice to the respondents. Shri,
Or identically, Lordship was pleased to issue dispose of identical case where some villages were transferred from Karimganj to Kachar district.
transfer of
Lordship.
village and
That is,
creation of a district, they are entirely two different set of circumstances.
That way also, another case was there, but that order is not here.
Representation.
Huh?
Representation order. This, in this case, it won't serve any purpose.
And number one, what private right has been infringed by this?
Right
Even-
of the citizens of the entire new district which has been created. We have,
They
you have to
will,
satisfy the,
they will
why-
not be deprived of anything, Lordship. All the schemes, benefits they are
the
getting,
chief
they will-
minister laying down the foundation of the DC office.
it will take several years.
Maybe then foundation, laying of the foundation,
It can be
also-
converted into a subdivisional office
Can-
also.
Saikia, can this be accepted?
No,
It
Lordship,
can
one
be,
thing
this
is-
can be
Lordship
done,
will
this can be the
kindly consider
alternative.
One point, 2016, the district was created.
Yes,
This foundation stone was laid in December 2022.
right.
And in the same month, 31st December 2022, their notification came for amalgamating it to the original place.
That is what we want to know, that when
We'll
the
file an
honorable
affidavit.
chief minister goes to the district, laying down the foundation stone, starting the works worth 425 crores, and out of the blue, within next 20 days,
Nothing has progressed within that 20 days time, Lordship.
the foundation stone laying ceremony precedes preparation of DPRs, map,
Absolutely, Lordship.
which also incurs
I
expenses.
fully endorse. And in our cabinet memorandum, I have gone through it. It is not that this is final. In future, again, it can be reverted back. I'll place it on record.
That's what we want to know, why
Lordship.
these uncertainties. Come out with the answer.
Lordship,
Issue notice to the respondents.
4 weeks time may be given,
Shri,
Lordship. We'll-
yes. Learned Education General, Shri Saikia puts in appearance on behalf of all respondents
Yes, Lordship.
of the respondents. Thus, formal notice need not be issued. Copy of the writ petition already provided.
one copy provided, further copy I will.
One
Extra
affidavit
extra
will file,
copies
Lordship.
of writ petitions writ petition be provided to Shri Saikia, who prays for and is granted 4 weeks to file counter affidavit. List
Highly
of
obliged,
4 weeks.
Lordship.
Deeply obliged.
Item number 3,
Yes.
May please your lordship. My lord, this is surfacing matter. And we have challenged one one-time settlement revocation letter, my lord. Now, as far as the entire case is concerned, now pleading is complete here because at the first day of motion, the other side took instruction and they filed affidavit, and thereafter we also filed the affidavit in reply. Now, my lord, while submitting, I respectfully apprise this honorable court that so far as the invocation of SARFAESI cannot be applied in the instant case because of legal bar, my lord. Now, I'll satisfy this on this point. My lord, so far as our payment is concerned, the initial loan amount was total 12 crore. One was 7 crore, then another amount was 5 crores. Combinedly, it was 12 crores. And against that, we have paid 17 crores already as per our record. But they have hidden the record. But our record do clearly say that we have paid total 17 crores, and thereby we have already paid 145%. Now, as per law, my lord, so far as section 31J of SARFAESI Act is concerned.
SARFAESI Act. Yes.
Yes, my lord. So far as section 31J is concerned, it does stipulate that if the total amount, whether it is capital or interest or combinedly both, if it is paid 81% above, then SARFAESI cannot be brought into the picture.
You are referring to section?
31J, lordship. 31J of SARFAESI Act. Section 31J, lord. Section 31J.
You have already acquiesced to the proceedings.
Yes,
by
my
going
lord.
in for the
Yes.
settlement.
And on top of it, my lord, actually, may I satisfy this honorable court that why we did not go to DRT? We ought to have gone to DRT. But during that relevant time, my lord, while the urgency arose, because suddenly they went out for holding auction proceeding, and on that time, for 3-4 days, landed presiding officer was not there. Number one. Number two, what happens? Too much urgency was there to challenge the auction sale proceedings, and SARFAESI cannot be applied because of this legal position. On
that
top of it,
position
my lord.
can be very well examined by the DRT. What prevents it?
My lord, what happens? Because that relevant time, now there is a provision, there is a case law also from Honorable Supreme Court that so far as the DRT jurisdiction is concerned, it is very narrow. It is with regard to only section 13(4), subsection 4. Beyond that, any dispute arises between the parties, borrower and creditor, the aggrieved party can go elsewhere. That is the law laid down by Honorable Supreme Court consistently, my lord. So far, while SARFAESI is not there, our question is, we have challenged the very proceedings because it is not maintainable ab initio. It is not maintainable ab initio. Now, whether DRT can decide on maintainability point. Our respectful submission is that DRT cannot go into the aspect of
Satisfy the
maintainability.
court that DRT can't entertain the challenge.
Now,
to the
on top of
proceedings
it,
on ground of
now, my lord,
maintainability.
yeah,
Yes.
I understand, my lord. Now,
Yes.
second limb of my submission is that, my lord,
Yes.
what happens now while they were invoking the SARFAESI, while they are
Yes.
going ahead with SARFAESI proceedings,
Yes.
suddenly they jumped onto another forum. They switch over to IBC, Insolvency Banking Code, and thereby they approach NCLT, my lord. Now, NCLT is seized of the matter. Now, in that situation, whether they can go ahead with the auction proceedings, and that too, very clandestinely, very clearly, we have shown that so far as the mandatory provision.
So you go to
As
the
laid down-
NCLT, file an application for getting a stay on the SARFAESI proceedings. That is the way out.
My respectful submission is while the SARFAESI is not applicable, and
Yes.
prima facie lordship, we are trying to satisfy this honorable court that SARFAESI can be dragged into the picture. In that situation, whether this honorable can entertain it under its jurisdiction.
Very well.
Despite apparently having the alternative forum, very recent decision is there that alternative forum
This is not
there
an
at all.
alternative forum. This is a statutory remedy. You have to make a distinction between an alternative forum and a statutory remedy.
Yes,
Authorized officer, State Bank of Travancore.
yes, my lord. But so far as the present grievance is concerned, my lord, so far as the present issue in controversy is concerned, that is beyond scope of section 7.
They have questioned your very locus to file these proceedings on behalf of the company on the ground that you are suspended from the board of directors.
My lord, now so far as the company is concerned, it is not declared as defunct. It is still corporeal body. But so far as the role of the director is
So the
concerned,
company's assets are, how the company's assets are to be
Lordship,
appropriated or adjusted. They
Lordship,
are a matter of CIRP.
Lordship, kindly, I may be allowed to
We,
complete my
here, don't
submission.
worry.
Kindly, I
but
may
we
be
have a
allowed
right
to
to put
complete
a
my
query.
submission. Now, what happens, whether one person, a citizen, can be prevented from approaching courts seeking justice?
Yes.
Now, so far as the director is concerned, he has been suspended in respect of affairs of the company, my lord. He cannot run the business of the company, but he cannot be prevented from approaching the honorable court seeking justice
On behalf of whom?
on behalf of company, my lord. But now, this is the motion stage. We have enough time for, if lordship allows, we can amend the petition. But for that point itself,
Why should we give you that suggestion or that advice?
but for that, because otherwise the director is qualified to approach this court seeking
That
justice.
objection is there in their counter affidavit, sir.
It is there. One lordship would kindly look into the aspect whether a person, he has been suspended and it is against challenge, my lord. It is under process, my lord. That is different issue. But so far as his activity in relation to business is concerned, there the bar has been imposed. But he cannot be prevented from approaching this honorable court, representing his own company.
Yes.
Taking advantage of this situation, they are taking all undue advantages, one after another. Now, so far as compliance of Rule 8, 9 are concerned, absolutely go by. Absolutely, it has not been followed. Now, and all records will clearly show. My lord, I'm having some difficulty.
Don't
I'm
worry.
running favor, that is right. So, this is our position.
You're
At
not
the prima facie
comfortable.
stage,
You're not comfortable arguing today.
Not comfortable, my lord. Actually,
Miss-
a lot of difficulty.
Mr.
I'm
Nayak.
finding it.
That's a personal difficulty.
That I cannot object. But only thing, Mala, there is a status quo in place.
We know.
That, but
We'll give a shorter date. Don't worry.
Lordship, if he is not feeling well.
Master.
And counsel for the
Status
petitioner.
quo may kindly continue because 145% we have paid. There is nothing to
Those
pay
are
from our
all,
side.
all questions of fact, gentlemen.
No, my lord,
So if
records
you-
are all there and they have
If you propose,
immediately admitted it.
if you have the strength to continue, we'll hear you and decide the matter. Don't worry.
Master, right?
And counsel for the petitioner, after addressing the court for some time, and counsel, Mr. So-and-so submits that he is not feeling well. And the matter may be adjourned for a few days.
Master.
List on 20th March, interim
Can
order.
it be on 21st?
21st,
Master.
interim order.
Much.
Matter number 4.
Service.
Lordship, I pray for 2 weeks more time, Lordship. I'm extremely sorry, Lordship, my apologies, but the brief is with the government counsel and he had to go for some treatment outside.
Very well.
So the brief could not be procured, Lordship. 2 weeks time,
Counsel,
Lordship.
So-and-so, praise for and is granted. Further opportunity of 3 weeks to take steps for effecting service upon the respondents.
Much obliged.
List after 3 weeks.
Matter number 5 and 6.
May I please the lordships?
Yes.
My lord, here are two items, item number, writ appeal number 1 and writ appeal number 9. In writ appeal number 1,
Before you commence, we'll put you a question.
yes,
Whether there can be any pension without a prayer of regularization.
yes,
Very well.
that may be.
Okay.
Because this was thoroughly discussed by our High Court, by a learned single judge. Thereafter, government filed an appeal and appeal was dismissed. So matter remained as ordered by the learned single judge. That is one aspect of the case. Second aspect of the case is this, my lord. The interim order is passed by a learned single judge, but the same single judge has provided pension to similarly situated person.
Okay.
So there is no judicial discipline, madam. On that point, I do not argue so much. I will show those that is a judgment, lordship may kindly see to.
Can there be a relief of equity against proposition of law? Can there be?
No, law is.
There are two questions which you have to answer. Firstly,
Yes.
there is no prayer of regularization in your writ petition. Secondly, there is no averment whatsoever that your client was working against a sanctioned post. There are two issues. You satisfy the court on that?
First thing, my lord, they are qualified person. They were appointed, but not in a regular process because they are appointed in the year 1992. So that.
They were never appointed.
Yes.
They were taken on roles, on muster rolls, plain and simple.
Master roles.
There was no appointment as such, sir.
An engagement letter is there, my lord. Engagement letter is there. And they were receiving salaries as usual. And they, during the course of this service, one person died, another person also he served for
Very
20 years and 21 years. Now, in some cases, there are more than 25 years, 31 years also. Their services were not regularized. Now, the Supreme Court says that bureaucratic delay, a person has committed a mistake. He has not regularized the service of one person, though he is entitled for. Then the government cannot take the benefit of their own laches. When they had to do their duties, but has not done, it does not will deprive the casual worker. My lord, they are casual worker. They are not so much a high-ranking official. So their services were not regularized by the government. In similarly situated persons, many cases they have regularized their services. Our services were not regularized. That was their mistake, not our mistake.
Sir, when you filed the writ petition, there was no prayer made that your client or your client's husband is entitled to
My lord, the
regularization.
Supreme Court says this, that of course, that may be one of the reasons, but that will not deprive the person. My lord, I
Very
have
well.
given citations. I am reading one citation.
Yes.
That is 2010. I have given citation to bench session just here because this, it is 2010, 9 SCC 247, para 11 and 13.
Let us-
If a qualified person,
Wait a minute. Qualified for what purpose?
for the purpose of MR labor, master worker, casual labor,
Is there any post for which the qualifications are prescribed?
qualification is prescribed means at that time, my lord, there was the person there working in Rod Mohora. In rods, they use access and hose, etc. and cut. So there are no formal education necessary. Some oral interviews are taken.
Very well.
And they
Read,
are
sir,
found
read the judgment.
2010 9 SCC 247,
Yes.
para 11 and 13.
ML Kesari.
My lord, 2010 9 SCC. Para 11 and 13, Lordship may kindly see. The object, I am reading.
Sir, can we read para 7 first?
7. It is evident from the above that there is an exception to the general principles against regularization enunciated in Umadevi if the following conditions are fulfilled. The employee concerned should have worked for 10 years or more in duly sanctioned post.
All right, now let us hold. Please satisfy us from your pleadings
Yes.
that your client's husband was working against a duly sanctioned post. Read the petition, please. Read, please.
Then first, my lord, I am taking this
Narzari.
WPC number 1.
Yes.
Now his appointment letter may be.
Ujjala Narzari.
Yes,
Read the pleadings in the writ petition, sir.
yes, I am reading. My lord.
Yes, please.
Para 3,
Yes.
sub-para Roman 2. The appellant wishes to say that
Sir,
that
read the pleadings in the writ petition, please.
writ petition.
First court.
Yes, para 39, para 2.
Yes.
That the petitioner wishes to say that let Ran Khamse Narzari was her husband and he was appointed as works as sectional assistant on 12/5/1997 and was placed under Kosugao Road subdivision under Kokrajhar PWD Rural Division However, from time to time, his service tenure was extended
Yes.
and renewed until he passed away on 6/5/2017.
All right, sir. Now, where is it pleaded that this appointment or engagement was against a post sanction under the relevant service rules?
My lord, your lordship is desiring to show me every legal points, but my submission would be to them, why they have appointed me? If there is no sanction post, why they have appointed me? I am a master
Casual
of-
labor, that happens, contract labor, casual
But my
labor.
service was never discontinued. My lord, it was continued till the death, till my death.
Irrespective thereof, supposing a man is appointed as a mason by the PWD, is there a post of mason? It is not. The person should refuse.
My lord, if the
Sorry,
temporary employee
You
is a
you read
part,
the judgment, sir.
well, I am
You
satisfied. my
you
lord.
cited the judgment.
If a
he pointed
temporary
out from-
employee is a part of permanent settlement, that should
Please
be.
point out from the rules that there is a post called work charge section of assistant in the rules. Please point out.
Well, if that is not there, why they have appointed? That is my
That's,
submission before that.
you sue them for torts. That you appointed me on a wrong post. You should have appointed me on a sanctioned post.
Well, I have other suggestions. I will satisfy your
So please
lordship.
satisfy us on this citation. We put your query on the basis of citation.
Now,
You read out.
for a moment, my lord, let the appointment letter be seen, my lord. Page 44,
Yes. Very well.
page 44.
Page 44.
Yes,
Read, please.
pending receipt of police verification report.
Yes.
And in pursuance of the Deputy Secretary, Borderland Autonomous Council, Kokrajhar, approved letter number so dated so and so, Sri Ram Khanse Narzari, son of Sri Vishnu Ram Narzari of village so and so, post office so and so, district and PS Kokrajhar, Assam is hereby appointed from the period eligible for 3 months. Now, lordship, kindly see here.
Sir, just hold on. This is a typed copy of the document at page 45.
Yes.
We'll throw out your writ petition for concealment of facts.
No, 45,
45 is the same document,
same document, yes.
right?
Yes.
You have
yes.
conveniently omitted to transcribe this document in the typed copy. Read 45. The
Yes.
appointment is purely temporary and may be terminated at any time without
Yes,
showing
that
any
is there.
reason thereof. Why is this not incorporated in page 44?
No, it
We
is.
take a
for
very
relevant
serious view of
portion.
this.
My lord, may kindly see there are dot marks are there. So
Why?
it means some portions we have not typed because every,
Is it your discretion to leave out a part of document which forms a record of the writ petition?
that is normally we do this, my lord. If a paper is.
Because
brown
that part
paper,
doesn't, this,
relevant portion we normally type.
Mr. Counsel, sorry, we
If
don't
that-
agree to this. This is concealment of fact and filing a false document in the court. This is the relevant part. You have intentionally omitted it. Can't be so casual in nature in your pleadings.
It was a neat petition, madam. It was a neat petition, however.
Yes, it was.
Yes.
When you file a typed copy, it has to be verbatim the same as the original document. Unless it is totally illegible, you may mention that that part is illegible, which it is not. The document is legible on the face of it. So why are you supposed to not transcribe this part?
That we have not done for that.
Yes,
madam.
all right. So now read it from the original, those lines.
Yes, then my lord, page 45, pending receipt of police verification report,
Same document,
same document,
incompletely transcribed in typed copy.
yes.
Yes. The
So,
next line is the line after what you have typed. Please read that. Second para.
the appointment is very temporary and may be terminated at any time without showing any reasons thereof.
So was it taken from the employment exchange? No, the executive engineer one fine morning says, all right, I give you the appointment. Is he the appointing authority?
My lord, our High Court has a decision that appointment should, it is not a must that everybody should come from employment exchange. That's a citation I have. If you are lordship.
Sir, you are reading the Supreme Court judgment. We have put your query based thereupon. Satisfy us on that he was appointed against the sanction post. Before proceeding any further, we would like your answer on that.
What a document. I cannot go beyond document.
All right. Then
So-
nothing in your appeal, sir. Yes, Mr. AG.
My lord,
You have anything else to say?
my lord, let me give some time, then I will satisfy in a better manner, because my lord,
We have time till
already
4:15 today.
petitioner has left this world.
Mr.
His
Mahmood,
wife is
We,
also
we
going.
have time till 4:15 today. Carry on.
Sanction post we have not seen here.
All right, how do you get
But
beyond?
Nature
get
of
beyond
the
this?
work, Supreme Court said, if the temporary employment is part of permanent employment, that should be treated as like that.
Sir, you
So
read
that
ML
suggestion
Kesari's
I may
judgment.
provide.
You read ML Kesari's judgment. How do you meet the requirements of para 7, please?
And my lord, our High Court has in division bench judgment, it has been
With due
upheld.
respect, sir, we are bound by the Supreme Court judgments. Not even the division bench judgments of this court. That is what Article 141 requires.
Now, my lord, may I show some other Supreme Court judgment also?
Yes, please.
Uh,
So we presume that
2003,
you have given up on ML Kesari.
Yes.
All right.
so
Proceed.
in that case, one case it says bureaucratic delay is not a ground to deny justice if he is otherwise entitled.
Very well.
Then minor, another citation of our Supreme Court, 1995, 6 SCC 227 para 1, last part. The workers, employees who have completed more than 20 years in service are entitled for pension.
Yes,
This is Supreme Court judgment, my lord.
yes, yes.
Then, my lord, Patna High Court's full bench judgment, that is, here it is said, my lord, that if the employee, casual worker, is entitled for pension, if he has completed 10 years, he will get temporary status. If he has completed 20 years, permanent status. So when permanent status, then he will get the benefit.
Very well.
Then, my lord, another citation, that is, my lord, writ appeal number 322/2016, order dated 21/9/2016. Here, our High Court held that,
Where is the judgment, sir?
I have given the citation back.
Is there a citation? Case numbers. You have the judgment with you, we presume?
This is the chairman, come managing
Read, all
director.
right, read the body of the judgment, sir.
Yes, my lord.
Read.
First, my lord, for this, for a better understanding, what was the order of the learned single judge which they challenged? But their appeal was dismissed, my lord. Let me show that judgment. my lord.
Sir, will Mr. Mahmood will
Well-
complete one argument and then shift to the next one,
This
please?
is the judgment. Appeal was filed and that was dismissed, my lord. So in that, my lord, single judge provided pension and other benefits. They preferred appeal, that was dismissed. So, my lord, I hope that ratio of that case is applicable in this case
Yes,
also.
yes, please. Read the judgment, sir. What is the ratio of the judgment?
Yes, that would be it.
Work charged employees.
Yeah.
Is there a pleading in our matter in this case that the deceased was a work charge employee? Any pleading to that effect?
MR labor and workshop employees are same, man. And workers,
Okay.
sectional assistant.
Yes,
In item W number 1, works as sectional assistant.
very well. Yes,
The last
read-
part, Lord Supreme Court
read
said-
para 5, please, of the judgment. You are having the
Sorry, my lord,
judgment?
Actually, I have given citation.
You're all right. Read this judgment. Pass it on. And then satisfy us how this is applicable. No, no. Yes, read para 5, please.
On account of the above decision, the workers employees continued in service and we are informed that although their services have not been regularized, they are being paid and paid the same scale of pay as regular employees. And in fact, they are working against sanctioned posts of the APAC.
So, right.
Yes.
So this is the crux of the matter.
Yes.
Working against sanction post. There is not even a whisper in your pleadings that your client was working against the sanction post. Yes, sir. Next argument, please.
In the context of the above status of the work staff, the question that was required to be answered in the writ proceeding is whether the classification between the regular and work staff employees of APHC is based on some rational differentia for the purpose of stipulating the retirement age under the same employer. The board resolution adopted on 1738 do not explain as to why the retirement age of the workers employees is kept unchanged as 58 years and or raised to 60 years for the regular employees. Thus, the absence of reasons in the board decision persuaded the learned single judge to grant relief to the petitioners. But before the division bench, Mr. D. Shaikia, learned senior counsel for the appellant, raised the plea of financial incapacity of the employer by reading the counter affidavits filed by the chairman of APHC and also by the deputy secretary of the finance establishment A department to project that the fiscal condition of the corporation was not good. And that is why further extension of service of works as employees was not considered by the APHC. The decision of the board of directors to raise the superannuation age of the regular employees to 60 years and to base it at 58 years for the works as employees is devoid of reason. It is well settled in the Commissioner of Police Bombay versus Govardhan Bhanji reported in AIR 39 1952 SC 16 that public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant or of what was in his mind to what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actions and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Now, lastly, my lord, the honorable division bench said that Lordship may kindly see para 14. The learned single judge in the impugned verdict noted that when the retirement age was raised earlier for corporation employees from 55 years to 58 years, the same was uniformly applied for all the employees, including the workers employees. Therefore, the departure made on this occasion did not find favor with the court. We have examined for ourselves the issue raised in the case and find no rational basis to differentiate between the regular and works as staff. Lordship, this is very important. Staff for fixing different retirement as for them. The learned single judge discussed all aspects of the case and based on decision on a sound logic, legal logic. Hence, we see no infirmity in the impugned decision granting relief to works as employees. Therefore, the writ appeals are found devoid of merit and same are accordingly dismissed. So, learned single judge in this case said that they shall remain in service up to the age of 60 years. They will get all pensionary benefits. That was challenged, that was dismissed. So what was in the mind of the authority, that is not material. What is prescribed in the order, that is to be taken. So we were appointed against particular post. We continued our services.
Sorry, sir, you are not allowed to make that submission. You are not appointed against any sanction post. There is no pleading.
Sanction order is not there, but.
Very well. So don't say that you are appointed against a particular post.
What is not there, how can I say?
So obviously,
Because
so
I
don't make
what-
such arguments. Don't advance such arguments. Yes.
I'm now basing the order of the Honorable High Court.
Yes,
As well as
we'll
Supreme
consider
Court.
it, of course. Please pass on the judgment.
We have 4 men, my lord.
Yes,
Already person is there. We are also on the way to go.
yes.
So some sort of concession.
Yes.
My lord, there is another order of the Supreme Court that court should provide justice even if the same be wrong interpretation of law. That is also the judgment of the Supreme Court.
Absolutely true. sir,
I can show
absolutely.
your lordship.
We'll give you the opportunity to get the same kind of relief. Don't worry.
I leave it to your lordship now.
Yes, Mr. Saikya.
So far as this last judgment, the issue was whether the workshop's employees should retire at the age of 58 or at 60 like the other regular. That was the issue. So there is no such issue that whether they are going to get pensionary benefits or not. That was not the subject matter.
Yes.
And the other part, Lordship, the Uma Devi's paragraph 53 is very clear. Three conditions has to be fulfilled.
Yes.
And there are several judgments. If the persons alive who are not allowed to get regularization after their death, it is absolutely not possible. So regularization is not feasible under the various Supreme Court judgments, ML Kesari, Uma Devi, followed by official liquidators case, and series of judgments till date. The law has not been changed.
Yes.
So in my humble submission, as they are not regular employees, the pension rules will not govern their case
Services.
for grant of pension.
Right.
This is my humble submission.
Okay. Dismiss.
So only
Thank you.
one sentence, my lord. What my learned friend said, that regarding age, that is a part is correct. Other discussion was that he will get every benefit.
We
like
will
pension,
consider
etc.
your, we'll consider. Please
That-
pass on the
that I will
judgment.
show just now. I have sent my junior to bring that.
You pass on the judgment, highlight the relevant portion, we'll consider it. Thank you. Dismissed,
Both the cases.
both.
Highly opposed.
Matter number 7.
Seven, my lord, I have been newly engaged. I seek some time, my lord.
In this case, my lord, as per the earlier order, my lord, earlier direction, my lord, whether that he can be appointed in any other post. That instruction I have received, my lord.
He can be appointed again.
Again, in any other post or not.
Okay,
That was the instruction, my lord, instruction I have received, my lord. He cannot be appointed.
he cannot be. All right, very well. Since council has been appointed now, engaged now,
That will
he'll
come on
complete his
record, my lord.
instructions and get back to us. The council, Shri so-and-so, Mr. So-and-so submits that he has been recently engaged to represent the appellant.
My lord.
In this case, he prays for and is granted 4 weeks time to complete his instructions. List
Leave
of 4 weeks.
Matter number 8 and 9.
Please, my lord. All of these. Detail.
My lord's matter pertains to certain persons who claim to be refugees from Myanmar, my lord.
Right.
And our contention is that, my lord, the law in force in this regard is a SOP promulgated by the Union of India, my lord. And we are requesting that that SOP be followed, and thereafter, your lordship, the process of the law may kindly.
Okay,
The SOP, your lordship, that was in force at the time the petitioners were arrested originally. Is that page number 122, your lordship?
yes,
And it continues to page number 123 and 124, your lordship.
right.
This SOP prescribes that the procedure to be followed by all agencies who claim when they're dealing with persons who claim to be refugees, your lordship.
Okay,
And it also it culminates with the provision of long-term visa or denial of long-term visa. And in case it is denied, your lordship, then thereafter they may be put in the detention centers and deportation proceedings may. be
Mhm. So
undertaken.
what has happened in the case of your clients? What is the procedure of visa or any proceedings to
Your
that
Lord-
effect?
Your lordship, the petitioners were granted refugee status by the UNHCR, your lordship.
UNHCR, okay,
Yes, your lordship. And thereafter they were arrested here in Assam, your lordship, in Karimganj district. Thereafter they were directly tried, your lordship.
and they've been convicted.
Convicted.
As per you, they have served out the sentence,
They have served the.
but
sentence.
still they are being detained.
Yes, your lordship.
Mhm. So what does the SOP state about this situation?
Your lordship, if your lordship kindly sees the SOP,
Page number?
page number 124, your lordship, a particular clause of the SOP.
Yes,
it says clause number 9, your lordship. May I
Yes,
read?
please. Yes.
It may be noted that economic migrants, that is foreigners who have arrived in India in search of economic opportunities without any fear of persecution, will not be eligible for long-term visa. If such people are detected, the cases will be investigated promptly and the persons will be prosecuted under the Foreigners Act, your lordship.
Mhm.
In our case, we are not economic migrants, your lordship. We have come due to fear of persecution and persecution, your lordship, in the state of Myanmar, your lordship.
Yes.
And that is why we're claiming that this SOP may kindly be followed in our case. And
Mhm.
if we are denied the long-term visa, your lordship. the process
Gentlemen,
of-
the question here is that you have already been prosecuted and you've been convicted. So how does this come to your benefit?
Your lordship, even because the prosecution and conviction has already happened, your lordship, but
Yes.
now even we have served the sentence, but we are
It's
still.
all
in the
right, but
sentence.
this clause of you being persons covered by the second part without any fear of prosecution. You are saying that you did not come to the country in search of economic opportunities. So you say that under this clause, you should be provided the LTV, but you have once been convicted under the Foreigners Act. Where's the question of LTV being provided to you? It's only a question of you being deported. And till that happens, you have to remain in the center. What is the legality in that? How is your detention illegal then?
Your lordship, when the matter was before the trial court, your lordship, thereafter, at that point also, the prosecution was aware of the fact that we were granted these refugee cards by the UNHCR.
That was for
Those
that court
documents
to
were-
appreciate. We are not sitting in appeal over the trial court's judgment.
Yes, your lordship. But
So
at this stage, in this SOP also says that if there is the maximum period of detention after the long-term visa has been denied is 6 months, thereafter they are eligible for release, your lordship, on bail. But we are not pressing for release, your lordship, but we're saying that we may be produced before the FRRO and thereafter we may apply for the long-term visa and the process of this SOP may be kindly be followed, your lordship.
you will tell us the position of law that person having been convicted under the Foreigners Act can seek visa.
Your lordship, because it does not say that this SOP says that if person claims to be a refugee, not that he is essentially a refugee.
Irrespective thereof, what is the consequence of conviction? Whether a person convicted under the Foreigners Act can claim visa. That is what the question is.
That is not dealt with in this, but we are, my lord, because we are from Myanmar and it is known across the world that
Yes.
the Rohingya community has been persecuted
That
there.
is true. That is true. Understood. But whether merely because they've been persecuted in Myanmar and they are here because of situations beyond their control, but once they've been convicted by a competent court in the country, whether this prayer for LTV is at all acceptable.
My
That
lord,
is a legal question you have to answer.
because your
And if not, the consequence of staying in the camps till a solution is found out, that is inevitable.
Your lordship, because Article 21 is available to all persons, your lordship. and
Right.
It says that the personal liberty may be curtailed by following the procedure established by law, your lordship. And in our case, your lordship, because there has to be a procedure that established by law, and this is the only procedure established by law, your lordship.
Mhm.
In case it says that your lordship, persons like us may be put in the detention center indefinitely, your lordship, then I have no case, your lordship. But otherwise we are, because they have also attempted deportation, your lordship, but the Myanmar has not responded. The state of Myanmar has not responded.
Right.
Effectively, we are under indefinite detention, your lordship. So your lordship, that is why we're saying that otherwise also there is provision in this SOP for third country deportation also, your lordship. But that is also not being done, your lordship.
Which country will accept them, gentlemen?
Because there are many signatories to the 1951 Refugee Convention, your lordship. The state of India may consult with them. And because this SOP is of the union government, your lordship, this
All right.
SOP says that third country deportation option is.
Mr. Chaudhary, what is your stand in this one? Yes.
Firstly, Lordship, the contention made that they were from Myanmar, that is refuted, Lordship, that is available in the judgment. In fact, the embassy of Myanmar has stated, if your Lordship will come at page 267.
Okay. 267.
267 in the judgment, it is quoted.
Yes.
So in fact, their writ petition was dismissed on the ground of giving false information, Lordship.
Okay,
And so far as the LTV is concerned, Lordship.
just hold on. Read.
Page 267, Lordship.
Yes.
The Embassy of the Republic of the Union of Myanmar presents its compliments to the Ministry of External Affairs of the Republic of India with reference to the latest note dated so and so regarding the national verification of 31 persons who are currently lodged in Assam and has
This writ has been dismissed on the ground that they did not provide the correct address.
certificate.
It doesn't say, it doesn't convey anywhere that they are not citizens of Myanmar.
Lordship, the Myanmar Lordship, they have not accepted the particulars given by them.
Maybe a man is landless, homeless. So people living on streets is not alien to our country also. What address they will provide?
Lordship, that
It's a human problem. Will you justify keeping them in the detention centers indefinitely? For how long the taxpayers' money will be used to feed them?
but that is one aspect of the matter, but however,
That is the most important aspect of the matter now.
in this part of the country, yes.
Yes.
In this part of the country, yes.
Then what? What is the solution? We already gone through one such crisis after the 71 war,
Lordship,
and the results are there to see. The
Lordship,
community is spread out all over the expanse of the country. Now, what to do with these people? How long will you keep them in detention?
Lordship, unless Lordship,
The government has to find a solution, gentlemen.
that is true, Lordship, but here, Lordship, the LTV, Lordship, that my learned friend has been referring to, that again has gone further change in 2020, a new policy has come in.
What is
Where-
that? What does that policy say?
That is only the people coming from Bangladesh, Pakistan and Afghanistan who are religiously persecuted. They may be given.
Okay, long-term visas, none others. Do we have that on record?
I do have it, but not today, Lordship.
Not today. Okay.
Lordship, I have the copy of the SOP brought in forth in 2019, Your Lordship. This applies to all persons who claim to be refugees. Your Lordship.
Claim to be refugees.
Yes, Your Lordship. It is similar to the 2011.
Understood.
SOP.
So, maybe say 9 o'clock.
15 minutes.
Huh?
15 minutes.
No. Okay, fine. Oh, okay,
But your case would be covered by part second of clause 2. Second subpara of clause 2. Because this action has already been taken in case of your petitioner's misconcept. They have been prosecuted and they've been convicted. So now all consequences which are to follow are as per the IPPR and the Foreigners Act. Because the very first clause says the second clause, documents available with the foreigner. These persons must not be having any documents.
They had, my lord, they had the UNHCR refugee cards, and the UNHCR refugee cards, Your Lordship, are considered by the government of India. The government of India has issued public notices in that regard, Your Lordship. Even the UNHCR's website says, Your Lordship, I have placed.
Mr. Chaudhary, do we have a decision on their prayer for LTV? Is there any decision?
or not an LTV option.
Is there a formal application or a prayer made anywhere to any authority?
No, Your Lordship, because we have to be produced before the FRRO. We have been confined.
Let us read your prayer in the writ petition.
Lordship, my prayers are at page number 61 of the memo of appeal, Your Lordship.
Yes.
It was a prayer for habeas corpus, your lord.
Understood. But now you are saying that there is a requirement of LTV being issued. Where is that prayer?
Those pleadings are there, your lordship, that the SOP, because the SOP was in force, your lordship, that is the law in our case, applicable to us, your lordship. So, your lordship, that procedure has to be followed, and if that is not followed, your lordship, my humble submission is that a habeas corpus would lie.
There is no question of these persons being released, gentlemen. Once they have been declared to be foreigners illegally entering into the country, is there any procedure under the Foreigners Act to release them? Let us have that.
The Foreigners Act, your lordship, because this is this SOP has been issued by the union government, your lordship. That power is there with the central government, your lordship. And we are not praying that we may be released from the detention center at this point or be allowed to move around.
Read para 1. The version of the foreign national making such claim will be carefully examined. Where is the claim?
Your lordship may kindly see the SOP will
Yes.
be followed whenever an FRRO or FRO comes across foreign nationals, your lordship. And also the directions, the first page of the SOP
Yes.
it requires that this SOP will be followed to deal with foreign nationals who claim to be refugees and to say that matters has been re-examined by the government, your lordship. Your lordship, any agency of the government who comes across persons who claim to be
Mr.
refugees.
Chaudhary, why don't we get this issue examined by the competent authority in accordance with the SOP? Pass a proper order so that there can be a certainty. They are convicted. They have already served the sentence.
Lordship.
To continue them in the prisons or a center indefinitely, that is not good for the country's economy.
Lordship,
Either you grant them LTV so that they can become useful citizens, useful persons,
Lordship.
giving something back as the other community is doing, or take steps for deportation.
Deportation, Lordship, again is a.
So whether we can permit these persons to be kept in prisons or these centers indefinitely.
That is one aspect which maybe.
The situation is that the state of Assam has had to create a facility of 3,000 persons. What kind of funds are needed for that? Even our High Court building doesn't cater to 3,000 advocates. So this is a serious issue. So can you make a statement that you will direct or advise the officers concerned to examine these cases in light of the SOP dated 20th March 19? Or if there is a later SOP?
There is a later SOP of 2020, Lordship.
We'll mention later SOP, if any,
Lordship.
which after hearing arguments advanced by learned counsel for the parties. Ms. Saikia, have you taken any decision regarding shifting them to this?
We have already shifted everybody
To
to Matia.
Matia? All right, so that part is taken care of.
That is total 217.
These persons are part of that.
Certainly, Lordship, because we had 6 centers in the state. Initially, in February, 1 center was transferred. They were all put in Matia. Then recently, Lordship, all other 5.
All right, so they are now already in Matia.
Your lordship, I think they were shifted yesterday, but I do not have the.
This is 13 March, yes.
Lordship, I'm appealing for item number 9, Your Lordship. Yes, Your Lordship, I have got the information that the petitions of item number 9 has been sifted, Your Lordship. I have gotten information.
Yes.
Your Lordship, in my case, Your Lordship, what happened? Already the petitioner number 6, Your Lordship, he has been deported. He is the son of Saidur Rahman.
He has been deported.
He has been deported to Myanmar.
Okay.
So he's in Myanmar now. So my prayer is simple, either deport me or grant me refugee status. In by the earlier order, Your Lordship, our honorable.
We'll take up first, let us pass the order in this one.
Oh, Lordship.
Yeah, for hearing arguments, during the course of arguments, the Advocate General, Mr. Saikia, has placed on record communication dated 13 March 23, issued from the office of the IGP, Assam, as per which, the petitioners herein have been shifted from the transit camps concerned to the transit camp at Matia Gopalpura. The communication is taken on record. Upon hearing and considering the submissions advanced by learned counsel for the petitioners and Mr. RKD Chaudhary, Deputy SGI, we hereby direct that cases of the present petitioners may be taken up by the competent authority. The claims of the present petitioners for grant of LTV may be considered by the competent authority in light of the SOP dated 20th March 2019 /SOP presently holding the field on the subject matter of this writ petition. Relevant rate appeal kar dijiyega. Relevant exercise in this regard shall be completed within next 4 weeks. 4 weeks. List thereafter. Yes.
Much obliged.
This matter, you say that petitioner number 6 has already been
Yes,
reported.
Your Lordship. Yes, yes, Your Lordship. He's the son of petitioner number 1. Your Lordship, petitioner number 1 and petitioner number 2 are two brothers, Your Lordship. And their families were apprehended, Your Lordship, and thereafter they were tried and they were convicted, Your Lordship. On 4/11/2014, they have completed their sentence of 2 years. 14. So it's been more than 8 years now they are in detention. Yesterday only they were being, yesterday or day before yesterday, they were being moved from Tezpur Central Jail to Matia camp. Your Lordship, my prayer is very simple, Your Lordship, whether deport us or to grant us refugee status. By the earlier order, Your Lordship, our Honorable High Court has arranged a video conference with UNHCR. And thereafter they were being satisfied, they were granted refugee card also, Your Lordship. So, Your Lordship, their citizenship status was earlier submissions of the respondent side suggest that, Your Lordship, their citizenships were verified by the embassy of Myanmar. And based on that, Your Lordship, petition number 6 has been already deported to Myanmar, Your Lordship. Now, Your Lordship, we are still in the detention camp, Your Lordship. And what has happened in the last 8 to 10 years, Your Lordship, some kids, Your Lordship, were 5, 6, now are 16, 17, they are deprived from schooling and all those things, Your Lordship. So it's a serious humanitarian crisis now, Your Lordship.
Mr. Chaudhary, you have not filed response to this petition so far. Why?
This has been tagged together, Lordship.
You have to, this pending since 2017. Many effective orders have been passed by this court.
Lordship, I will come up with a response.
All right. Because this is basically between the petitioners and the Union of India.
Lordship.
So whatever actions are required to be taken, one of them has been reported. The others are family members, most of them.
That the other country has to accept that, Lordship. That is the main problem, Lordship.
That's right.
If the same situation is ensuing between India and Bangladesh, Lordship. Although there are so many illegal immigrants, Bangladesh is
Not
they are not
accepting.
our people.
Naturally. That's how they propagate.
And so far as, Lordship, this UNHCR cards are concerned, Lordship, these have been procured after they have finished their sentence.
All right.
And India is not a signatory to the refugee
That
convention.
pleading we have seen in the earlier writ petition, earlier
Yes,
appeal.
Lordship.
Mr. RKD Chaudhary, Deputy SGI. Praise for and is granted 4 weeks time to file counter. List up to 4 weeks.
Letter number 11.
Connect कर दीजिए, connected ही है ना वो 4 weeks आ गए.
हाँ.
Yes.
Yes.
In terms of the order dated 28th February, Lordship,
Yes.
the whole issue was re-examined and we have brought it in a seal cover, whatever
right.
decision they have.
Let us see. Yes, brother, please, 828, if there is an issue regarding the 3 bids at the same rate. We have re-examine everything. Yeah. Open it. So, all right. The appeal has become infructuous with this decision.
Yes, sir.
Please share it. Now another round of litigation will ensue.
My friend will be very happy, Mr. Nair.
No, why he'll be happy? The work has been awarded to the appellant. Pavitra Baro. Yeah,
the-
he'll be happy
for the
because.
litigation
Yes,
part, my
yes,
learned
yes.
friend will be
He'll be happy because another round of fees will be coming around.
And I'll have to get ready with a caveat.
Yes, with a caveat.
Lordship would not pass an order.
No, you read it, please.
No, my lord, if your lordship can have a date, because what cursory thing is that.
No, you'll need more time to prepare the writ petition.
No,
Well,
I'm not.
well, he wants to-
I'm arguing on this point. What had happened here?
Yes.
When the tenders were issued, my lord, that aspect, my lord, in all probability has not been considered. Whether he was a responsive tenderer or not, that is what the honorable single judge has considered. So honorable single judge,
Now much water has flown, sir.
no, my lord,
The
it's
work
still not
is
flow.
stuck since long.
No, my lord, it's not.
You will have your remedy.
No, my lord.
There are two remedies available to you.
Lordship-
Either to challenge our order dated 28th February before Honorable the Supreme Court. That order was passed in your presence.
Which one, my lord?
28th February, the previous order whereby we had
Status
directed
quo.
them to reconsider.
No, my lord, I had made a submission. My lord said that my lord will hear me, my lord.
Yes, of course.
My lord will hear me on that. So, my lord, and therein that order does not say that only, my lord, you're treating, my lord, the appellant has been treated to be a responsive bidder.
Right.
Because by the orders of the honorable single judge, he's a non-responsive. My only prayer, my lord, before your lordship. is,
Right.
Here they have said that they have considered some works. They have considered some works and found that
All right.
The-
So you get an order, you argue the matter on he being responsive or not. Okay. That is the only thing now required to be seen.
and
Argue
one more
it.
thing, my lord, one more thing.
Yes.
Here, my lord, here they have said, they have given some works. They have taken one work of mine.
We'll ask learned advocate general to share
Just
this
give me a
document
copy.
with you.
My lord, I'll make my
Various
submissions.
merits.
If this argument is accepted, my lord, there won't be any end to any litigation because the decision has been given in terms of a court's
Mr.
order.
Das, very well. He has the right to contend.
Yes, on the
That yes.
decision-making process, if you are the
Yes,
first
yes.
round, he could not get any ground.
Yes.
Let him try the second round.
Very well.
Decision he cannot, sufficiency and adequacy of the government to give a contract. He cannot fetter the government's power not to give contract.
That's right.
Absolutely.
In pursuance
He
of
can try his
the
luck, not.
direction given
Well,
by
I
the
may be
court.
served a copy.
Yes, on 28th February 2023, the matter regarding the tender in question was examined by the competent authorities of the state government. Full stop. After consideration of all associated documents and
They have only considered the three, only whether how many works they have done in. previous. Not
all
considered.
relevant documents, the
Responsiveness was.
state
not considered.
authorities have found the appellant, bit of the appellant compliant of the requirements of the NIT in question.
My lord, I think that may not be.
That is
correct.
there.
No, it's not there, madam. It's not there. That is not the projection. They said that he had done 4 works completed, so we are giving it to him. That aspect has not gone into, madam. Whether it's compliant.
We have given our due consideration to the facts and figures submitted by all the equally placed L1 bidders.
Yes, madam.
We have also re-examined all the relevant documents and have made an objective approach to the above facts, since all equally placed bidders are financially stable as per their submitted documents, past experience becomes the key factor while arriving at the present decision. Taking note of the past performances of so and so, we hereby deem it proper to select and allot the work so and so.
Lordship.
Quote this para. The competent authority has decided as below. Then council, Shri Das Nair prays prays that the copy of the order dated 9th March 2023 may be provided to him so that he can address the
Lordship.
court on the issue of the qualification of the appellant
Lordship.
for being awarded the work in question.
Lordship.
I pray for a short date, Lordship. And
List on 22nd March.
22nd month.
Yes,
Lordship, much obliged.
the document is taken on record.
Lordship.
I may be
Copies
given-
thereof be served on respective council representing the parties.
Lordship, much obliged.
Get copies made and provided.
Item numbers 12 and 13.
May I please?
Yes.
Lordship, these two writ appeals have been transferred from state of Manipur to this High Court, Lordship, by way of a Supreme Court's order. So Lordship, this case relates to Lordship, this is hockey, the affairs of hockey in Manipur. So factual matrix is Lordship little bit lengthy. So Lordship may kindly bear with me so that I can place the factual things. Lordship, this Manipur hockey is basically run by, earlier it was run by two organizations. There's Manipur Hockey Association and Manipur Women's Hockey Association. These two organizations were Lordship registered organizations, and those were registered in 1976.
Right.
So affairs were going on like that. They were conducting this Manipur hockey in Manipur. But later on, Lordship, this, as your Lordship also is also aware, because of commercialization of sports, a lot of things started happening. And there were some disturbances like selecting players correctly. And all these things happened. Then what happened, Lordship, in 1/6/2009? 1/6/2009, what happened is that Indian Olympic Association, they have de-recognized these two organizations, Indian Hockey Federation and Indian Women's Hockey Federation, and they formed one organization called Hockey India. So they were with the logic that there will be only one organization that will run the show. So Hockey India has been formed, and then what they have done, they have written to all respective states, all state Olympic associations to form one organization only. But they have not mentioned anything that earlier organizations, two organizations will be amalgamated and form one organization. They have not stated anything like that, but they have said there should be one organization only, which will look after the affairs of the hockey.
Right.
Now, Lordship, pursuant to that, Lordship, that Olympic Association of Manipur, they have organized a meeting, and accordingly, they have formed an organization called Hockey Manipur.
Right.
So Hockey Manipur, it was supposed to be made by amalgamating these two organizations, the Manipur Hockey and Manipur Women's Hockey Association. But in that meeting, Lordship, this decision was taken for amalgamation. Now what has happened here, Lordship, since this ad hoc body of Manipur, Hockey Manipur was established. So what they have done, they have de-recognized these two organizations, Manipur Hockey Association and Manipur Women's Hockey Association. Now, Lordship, this took some time for amalgamation and all, and during this time, a lot of problems arose because of this de-recognition of these two associations. So at that point of time, Lordship, there is a lot of concern has been raised, and there are two Olympians, Lordship. One is led by Mr. Toiba Singh, is a very famous hockey player. He thought that there should be something should be done for the betterment of the hockey in Manipur, because these two organizations are not working now. So in the meantime, a lot of loss happened to the hockey in Manipur as a whole. Right. So what these people have done, they have issued some circular for calling of a meeting. So in this meeting, Lordship, on 6th of October 2001, meeting was held. There, Lordship, a lot of former players Olympians, World Cup players, as well as
2001.
2009 year also,
Nine.
6/10/2009.
Okay.
So in that meeting, lordship, players from both the organizations, I mean, from the earlier as well, this Manipur Hockey Association as well as Manipur Women's Hockey Association, they also participated. And officials from the Manipur Olympic Association also participated. And there was a decision taken that one organization, one body will be formed that will be named as Manipur Hockey. So that was a decision taken, and accordingly, this Manipur Hockey was formed. And they have applied for affiliation under the Indian Hockey Association, that is, which is required for participating in the national games and international games.
Right.
So affiliation was given to them, and while giving the affiliation, this Hockey India has stated that though affiliation has been given, but like this organization, this body has to be registered under society's registration like of the particular state.
Right.
So particular state. Accordingly, lordship, this hockey organization named Manipur Hockey, they have been registered. They have been registered on 12/11/2009. Lordship, this date is very important. 12/11/2009, this organization has been registered under Manipur Society's Registration Act 1989.
Right.
So after this registration, lordship, that ad hoc committee which was formed by the Manipur Olympic Association, that Manipur Hockey Manipur, lordship, that has been cancelled by the Manipur Olympic Association. That has been cancelled on 23/12/2009, lordship. Now, after this registration, one appeal was filed before the Commissioner Secretary Register of Societies by the Manipur Women's Hockey Association, stating that this registration, that basically they're asking for cancellation of this registration.
Right.
But though there was no provision of appeal for cancellation of registration, but they filed an appeal.
So the registered cooperative society.
Registered cooperative.
Right.
Registered corporation. Then what happened, lordship? On 21/1/2010, the date is very important. 21/1/2010, this Manipur Hockey Manipur, lordship, Hockey Manipur, this was formed by amalgamating these two erstwhile organizations. Now this was done, and this has been named as Hockey Manipur, and registration certificate was given. Now, in the meantime, what they have done, that Hockey Manipur, they have filed a writ petition before the Honorable High Court of Manipur, challenging the whole process of registration of Manipur Hockey. So that was challenged, and this writ petition was disposed of by the Honorable High Court on 17/3/2016. This was filed in 2010, your lordship. Writ petition was filed in 2010, and it was disposed of in 17/3/2016. And in fact, like lordship, while disposing of, only thing that has been stated in the order is that the representation dated 4/1/2010 that has been filed, that should be disposed of within a period of 2 months. Now, what happened, lordship? This Hockey India has issued a letter on 10/1/2011 to the Youth Affairs and Sports Ministry of Manipur, stating that they recognize only Hockey India. Hockey India, nobody else. Then, lordship, this direction of Honorable High Court was complied with on 22/8/2016 by the Principal Secretary, Corporation Department, whereby Principal Secretary has given 6 months' time to reconcile between these two parties, Hockey India, Hockey Manipur and Manipur Hockey, so that like they can come up with some resolution and they can form one organization together. And they have been given 6 months' time. Accordingly, lordship, the effort was made from Manipur Hockey to bring on board this other organization that is Hockey Manipur, so that some reconciliation can happen. And accordingly, 2-3 letters have been written by them to the parties, to the other party, as well as requested the Manipur Olympic Association to organize a meeting so that some reconciliation can happen and one organization can run the whole show. But nothing can happen, lordship, and the other party did not come for joining in the meeting, so that there is no fruitful thing happened after the meeting. So on 22/5/2017, your lordship, the Principal Secretary of Corporation Department passed an order on the basis of the representation filed by the Manipur, Hockey Manipur, that the registration of Manipur Hockey should be cancelled. He passed that order. He passed that order without hearing us, we are hearing this Manipur Hockey. Then Lordship, subsequent to that Lordship, he realized the mistake that like this under the registration, Manipur Registration Society's Registration Act, this cannot be cancelled. So what he has done, he has revoked the order. He has revoked the order on 14/6/2017. That cancellation order, your Lordship. Then subsequently, Lordship, on 27/6/2017, again, this Hockey Manipur has submitted another representation for cancellation. Then in pursuant to that representation, Lordship, what has been done, the Deputy Secretary Corporation Department has issued summons to both the parties to come for a meeting. And this summons was in fact, Lordship, challenged by Manipur Hockey, filing a petition before this, before the Honorable. Then on the, so now Hockey Manipur passed their order on 19/12/2017. High Court passed an order stating that the Manipur Society Registration Act did not envisage any cancellation of registration. So this summons which was issued pursuant to that is not correct. So it was this summons were dismissed.
Can we have a look at the Manipur Cooperative Society's
Yes,
registration?
okay, I'll just touch it. I'm sorry, Your Lordship, that I think that must be the rules. These are the acts, Lordship.
Yes. Act, you know.
These are the rules, these are the acts. So basically, Lordship, the Honorable High Court was on section 11. So this summons were basically issued under section 11. So section 11 says something else, Lordship.
Right.
So it says about, Lordship, the state government may direct change of name. So that was the reason, precise reason, Lordship, that summons were cancelled.
Yes.
So after this order also, Lordship, on again this Manipur, after this order, Lordship, the summons, once the summons have been cancelled, that Manipur Hockey has filed a representation.
Representation.
Yeah, the other, I have Manipur Hockey, whom I am representing, Manipur Hockey has filed a representation before the Secretary of Cooperative Societies.
For what purpose?
They have stated that that Manipur Hockey Manipur, which has been given a registration, actually this should not have been registered because already a similar organization named Manipur Hockey is already existing. So under this society's registration, it cannot be done. So in that matter, Lordship, the representation was filed by Manipur Hockey.
Right.
Now on 22/1/2018, what has happened? The Secretary Corporation Department of Manipur passed an order whereby Manipur Hockey was directed to change its name within 3 months. So actually, Lordship, what has happened is that like Manipur Hockey has represented that Hockey Manipur should not have been registered. But this cooperative Secretary Cooperative Society, what he has done, he has asked Manipur.
So basically, it is that Hindi is saying, Chaubeji, Chabbeji hone gaye aur Dubeji ho kya gaye.
Yes, absolutely. So that has happened. But
why doesn't a civil suit lie, sir? Answer the query.
So,
why are the orders not amenable to challenge in a civil suit?
Yes, it is amenable, Lordship, that is there, but
Then why a writ jurisdiction is to be invoked?
Lordship, I mean, I want to appeal now. At the stage of appeal. So now.
So whether this objection can't be raised or whether this ground of lack of jurisdiction can't be a reason to throw out your appeal at this stage.
Lordship,
Plain and simple, you want a decree against the order of the registrar.
Lordship, what has happened, a lot of things have happened, the factual things have happened. Now, what has, this order was actually challenged. This order was challenged by Manipur Hockey.
By filing a writ.
By filing a writ.
And the writ court says do it in 3 months.
Writ court says that, yes, change it in 3 months. Then other side also, they have also filed a writ petition stating that like they want the implementation of the order dated 22/1/2018.
Both of you are fighting to ensure that the Manipur hockey never comes up to the level it ought to be. That is what your litigation is taking it to.
No, now Lordship, what is happening is that like this Manipur Hockey is the only organization which is affiliated to Hockey India.
Hockey India.
Now whatever the sports is, sports.
So why are you bothered by their registration?
No, now what Lordship, they have issued a letter to us, letter to Manipur Hockey stating that.
Who has issued?
This is Hockey India.
Okay.
Because there was supposed to be an Eastern India competition starting on 19th of March. And since Manipur Hockey was the affiliated organization, they have been invited to participate in the organization.
Okay.
Now, because of the order of this honorable court, now they are saying that we won't be able to participate. So that is the problem. Now, Lordship, I am challenging this single judge order in few points, Lordship. That Lordship, I'll just point it out to you, Lordship. And in the meantime, Lordship, what has happened since this matter was before the Supreme Court for transfer on status quo order was passed at that point.
On the order of the single bench.
Single bench.
Okay.
That was.
So
passed.
then Hockey India might not be causing a difficulty. It might not be difficult
No,
for you.
Lordship, what has happened, like while,
Yes.
while disposing of the transfer order, nothing has been stated about the
Status quo order.
Status
Okay.
quo order. But initially status quo order was passed.
Okay.
Now the problem is happening that like all the players are like they're getting stuck.
You're right.
So Lordship, at this point of time, Lordship, what I pray is that Lordship will hear this matter, like it may be heard.
Yes, Mr. Saibala, what do you say?
Also, but
Let the players participate.
At this point
In
of
your
time,
quarrel, these are quarrels. Mujh ki ladai.
yes, Lordship.
Let the players not suffer.
Correct. Only thing, your lordship may just see section 10, my lord, of the decision.
No, Lordship, I'll have to submit then.
We will straight off relegate you to go before a civil court and file a suit. This is not a matter of writ jurisdiction at all. So please let the players play the game in the spirit of the game. You are staying the single bench order. You come back on the next date and address the court on why these disputes should be entertained in the writ jurisdiction. Satisfy the court.
So, I think, my lord, your lordship will see.
Yes.
If your lordship will see just section 10 of the.
Was there a status quo order in the Supreme Court in the transfer
It
petition?
is not there, my lord, letter.
No, it was there.
While disposing of the.
Please don't make a statement before being assured.
No.
Let us see the order.
While disposing of the matter, my lord.
Disposing of, yes. So we are continuing that proceeding now pursuant to Supreme Court directions.
My lord, only thing, my lord, your lordship will see that both the orders which were passed by the judge, section 10 of the act, my lord, says, if your lordship will see, my lord.
Then Lordship, I'll have to argue on a couple of other things here. Lordship.
Yes, sir. What does section 10 say?
Then, no society shall be registered under a name which is identical with or too nearly resemble.
Sir, please read section 19 then.
19.
All right. We decide the dispute right now and here. Saying that a suit lies, go to the civil court. There's an express provision for a suit.
It's against the society, my lord. So,
The society may sue or may be sued. So, all right, the society is aggrieved by registration of another society in a similar name, deceptively similar as you say, file a suit. But we are not going to leave the players in a lurch. We are staying the order to address the court on this issue. All right. Heard and counsel for the parties. Mr. your good name, sir?
Yeah, Anjan Kalita, Lordship. A Kalita.
A. Kalita, Learned Counsel representing the appellant in writ appeal number 27/2023. In both appeals,
By both.
you are representing, the appeals are by the same
Yes.
body.
Yes.
Urged that
27-20.
the matter has been received, you start here, these writ appeals have been received in the Guwahati High Court upon being transferred from the High Court of Manipur by order dated so and so passed by Honorable Supreme Court of India. During pendency of the transfer petition, Honorable the Supreme Court, both the appeals are directed against the common judgment dated
27-20.
27-20.
20th July 2022, passed by learned single bench of High Court of Manipur, whereby, the connected writ petitions number so and so were disposed of in the following terms. Mention it from page number 53, subpara 61, para 2. Full stop. While entertaining the transfer petition, Honorable the Supreme Court, initially passed an order dated 11/10/2022, directing to maintain status quo as regards the registration of the applicant association. The transfer petition was finally decided by order dated 7th December 2022, whereby proceedings of both the writ appeals have been transferred to this court. Then counsel Mr. Kalita, representing the appellant, urges that what are the games commencing?
Lordship.
Which games are commencing on 19th March?
Eastern India.
Give it in a slip. Submit that the appellant is the only society recognized by the Hockey India.
Zone Championship.
Hockey India, full stop, on account of the situation created by the impugn order, the Hockey India is not allowing the team of Manipur to participate in the East Zone Championships scheduled to be held in Odisha on 19th March 2023. He thus urges that until the writ appeals are decided, the impugn order passed by learned single bench deserves to be effect and operation of the impugn order passed by learned single bench deserves to be stayed. Mr. Sahibullah, representing the respondent number so and so, opposes the submission made here and above. Having considered the submissions advanced at bar and keeping in view the interest of the players, hockey players from Manipur to be of paramount consideration, we feel it just and proper to direct stay of the impugn order dated so and so. Thus, it is ordered that effect and operation of the order dated so and so shall remain stayed till disposal of the appeals. List the appeals for final disposal in the month of June. Let the players carry on with the sport.
Item number 14.
Yes.
This matter pertains to demolition of a residential building, Your Lordship.
Pertains to
Demolition of a residential building, Your Lordship.
yes.
There's one connected writ appeal, Your Lordship, writ appeal number 63 of 2023.
You want that
May
to
I
be
pray
tagged?
that both these may be listed together, Your Lordship.
Lordship, if Lordship decide this issue, nothing survive, Lordship, only one page, Lordship.
That is why
Page 105, Lordship, for a moment.
105.
My lord, we raised the complaint and that was noted, filed writ petition, writ court has directed to authority to take into consideration all facts and this order was passed 105.
Just. The operative part is at page number
105, my lord, can you see, there is a certain violation that has been found, 105. Page number
105, yes.
Letter dated 1/12/2022. And lordship, these are the violations, normal violation, my lord, setback, etc. And my lord, I am reading this paragraph. The Honorable Guwahati High Court in order dated so and so directed the undersigned to take appropriate step and action in accordance with the law by noting the deviations found and recorded.
Deviated portion is ordered to be demolished.
Yes.
Only.
Now, lordship, kindly see the next page, page 106. They have accepted. Page 106 is their representation. Last two paragraph. I hereby state that the time sought to demolish the deviation is for the purpose of calculating compound of deviation, then demolishing and not for approaching any court. He admitted. Let me. Therefore, I request you to grant 10 days time for demolishing the deviation stated in the letter. I shall be thankful to you. Lordship, he has already admitted. Now he's challenging.
A little portion we have already demolished also, Your Lordship.
Now,
So they have asked
portion
you
we
to
have already
demolish
demolished.
only the deviations.
Exactly, my
Nothing
lord.
beyond that, not the entire structure.
Your Lordship, this impugned letter is itself is under challenge, Your Lordship.
Which one?
105, Your Lordship. Page number 105.
But thereafter you have agreed to it.
Exactly.
Acquiescence, how can you challenge it? You yourself admit that there are deviations.
The entire deviation we have stated in the letter itself, the next
Yes,
page, Your
what?
Lordship, that the compoundable deviation, whatever is compoundable, we are willing to pay the amount for that, Your Lordship. And regarding the other portion, we have
Is
already
there a
demolished.
right of getting the deviations compounded? Shows the provision in the Municipal Act.
That I'll provide you. The
Please
only
show.
thing is, Your Lordship, the other writ appeal may come up.
Forget
Your Lordship.
about that will be covered by this order.
Exactly, my lord.
What is the problem? Show us the provision that the person who deviates from the approved site plan
Your Lordship,
has a
then, Your
right
Lordship,
to seek compounding.
Your Lordship, then Your Lordship may kindly come to page 66 of the writ appeal first, Your
Page
Lordship.
number
Because the entire fact of the case is different.
Page
Page
number
66, Your Lordship.
66.
Your
Yes.
Lordship, before reading out this letter, Your Lordship, I must state, Your Lordship, he is the respondent number 6. He is staying on the southern side of my building premises, Your Lordship. And this letter now, Your Lordship, dated 12/4/2021 is given by the last mandal after verification, Your Lordship. The last sentence is important, Your Lordship. On measuring the land on the western side after leaving so and so feet from the road, I have found the measurement of 55 feet in place of 58 feet on the petitioner's side. So there was encroachment on my plot of land, Your Lordship. That is my entire case. And now that.
Sir, those are disputed questions of facts.
Technical, my lord.
Whether they are to be seen in the writ jurisdiction.
Your Lordship.
Question here is simple, plain and simple question here is, your client has admitted to having made deviations. Now he says, I will demolish those deviations which are not compoundable. Regarding compounding, you have made a prayer. So you go to the authorities. If they don't act on your prayer, then you have to
Your Lordship,
take appropriate action.
Your Lordship, I can go there, Your Lordship, but because of.
That is the ultimate
and-
solution, my lord.
But
Lordship, what happened now, Lordship, they're taking the building bylaws very, my lord, lightly in everywhere, my lord. That's why. my lord,
That's why that is
that's
happening.
a different.
Now they're playing technicalities, but question is that, my lord, deviation he has himself admitted, my lord.
Yes.
So
Your
therefore he has
Lordship,
to
not the
remove and
entire
make it
deviation. I
correct,
have
my
not
lord.
agreed.
Nothing is wrong, my lord. And my lord, expert committee constituted by the direction of this honorable court, Lordship, just see for a moment, 105, my lord. Page 105. That is
Yes.
the expert committee which found that there is a, my lord, violation. My lord, page 90.
Yes.
90 is the, my lord, letter which was a order issued in terms of the Honorable Guwahati High Court direction, and Lordship, can you see? Town planner, executive engineer, assistant engineer, technical branch, Tinsukia municipal. These all the technical person, my lord, and
Yes.
found that certain violations.
Yes,
are
this is
there.
important, Your Lordship.
Then,
Yes,
my lord, if suppose this technical committee, if we say that they are not competent person, then who will be the competent person, my lord?
now Your Lordship may kindly turn to page 91. Everything will be clear now, sir.
Yes.
Your Lordship, these are the four persons
Please
appointed.
give us Municipalities Act. Yes,
Page 91, Your Lordship.
yes.
This is the report given by them. Your Lordship, at page 90, there are four persons named, Your Lordship, for the committee. And this report is not signed by any of them, Your Lordship, except one. And some other person has furnished this report, Your Lordship, prepared this report, Your Lordship. And on the basis of this report, the deviation has been, as per the letter that Your Lordship has seen at page 105. That
Yes.
letter was on the basis of this report, Your Lordship. And why I am submitting the other writ appeal is important, Your Lordship, because this entire field verification report was prepared on the basis of an order passed in a writ petition, your lordship.
Yes.
That writ petition order is in salience in that another writ appeal, your lordship. That is important, your lordship.
Yes.
If your lordship may kindly take up both the matters together, it can be heard and disposed of, your lordship. Any day, your lordship.
Picture is very much clear. He himself admitted.
No, that
about
writ
this.
appeal is important, your lordship.
What remains, my lord? The law estoppel
The-
applied.
Yes.
At page 90, the committee is given, your lordship, and none of them has signed the field verification report, your lordship, at page 91. And I can show the anomaly, that the other writ appeal come, your lordship.
My lord, no purpose will serve. My lord,
And
this is
at
crystal
page
clear.
92 itself, both the drawings of this, the building are given of two separate stages, your lordship.
My lord, he wants that the disputed fact to be reopened by the writ jurisdiction.
Can't-
my
No,
lord.
be
not
done.
disputed, your lordship, this is a matter of law, your lordship.
And my lord, violation has to be taken in my lord, with strict hands, my
May I
lord. That
pray, your
position
lordship? Only
will
1 week
become
time
very
I pray, your
dangerous, my
lordship.
lord.
After 1 week, both the writ appeal may be taken up together and can be disposed of, your lordship.
They will get a grant, my lord, otherwise, my lord, nobody
Yes,
will, my
true.
lord, have
There
fair
must be a
about
provision
bidding,
of
my lord.
appeal, brother. There must be a provision. Is there a provision for appeal in the Municipalities Act? In the corresponding Rajasthan Municipalities Act, there is a provision of appeal.
My lord,
So if
yes,
there's an
yes,
order, you
yes.
are agree, appeal or revision, either it is appeal or revision to the state.
Yes, but that order is passed on the basis of a judicial order passed by this honorable court. That is why I cannot go, your lordship.
This is an order
That's
based on,
1-2, the order that my learned friend has shown, your lordship, at page 105. This
yes.
demolition order was passed on the basis of a judicial order, your lordship.
Which order,
Passed in a writ petition, your lordship.
which is that order?
Yes, your lordship. At page 81, your lordship.
81.
Yes. I have challenged this in the other writ appeal, your lordship. 10-3-2022 order, your lordship, as page 87, your lordship,
Yes.
the operative portion. Oh, sorry, your lordship.
No,
Sorry,
this
sorry, your
order,
lordship.
my
Sorry,
lord,
at page
I think-
86. I'm sorry, your lordship.
My lord, the final order is, my lord, in page 102, my lord.
102.
102 is the final order, yes, your lordship.
102, my lord. Operative part start from page 103.
103 is the date of the order, your lordship, 3110.
Yes.
And at page 104, your lordship, if I may read out the penultimate paragraph, your lordship. In view of the clear findings which till now have not been challenged by the affected respondent number 5, the respondent authorities, namely Tinsukia Municipal Board, are directed to take appropriate steps and actions in accordance with.
Who was
law.
the respondent number 5 in the writ court?
Me.
You were.
Yes,
So
yes.
you chose to sleep.
No, your lordship, that is at page 103, your lordship, page 103. I
Yes.
couldn't appear only 2 occasions, your lordship.
Only 2.
So, my lord,
Your
prior-
Is there-
lordship,
is there
there
any-
was some-
Prescribed limit?
No, your lordship,
How many
no,
times?
no, I admit, that is my fault, that is my fault.
Then, all
That is my
right.
only fault, your lordship.
Then you file a review.
Otherwise, your
Then you
lordship,
file a
that is-
review.
Your lordship, that is why I went for review of the order also, your lordship.
321 Municipalities Act.
my lord, yes, my lord. Appeal from the
Read.
order.
Yes, that is why, your lordship, I can do that, your lordship. But only thing is, since this 31-10-2022 order passed in the writ petition, your lordship.
Yes.
And this, again, if your lordship may kindly come to page 105, your lordship.
Mhm.
This was the subject itself, your lordship, at page 105, regarding your under construction and the judgment of the Honorable High Court in
And
WPC
gentlemen,
number
you
227.
never represented before the learned single bench.
Thereafter, I filed a review, your lordship.
Yes, review.
Was
That also
dismissed, and
dismissed.
I am before this court by a writ appeal. That writ appeal may kindly be tagged with this writ appeal. That is my only prayer.
My lord,
After 1 week, your lordship.
My lord, the.
If that writ appeal comes, your lordship, I am
My lord,
satisfied.
my lord, only one thing.
Let that
Only
writ
one thing,
appeal come up.
Yes,
my
yes,
lord.
your lord.
No
Don't make any difference.
Yes, your
My
lord.
lord, there is no problem. Only thing is that, my lord, the deviation is, my lord, crystal clear, my lord. The
We will-
building cannot be, my lord,
Naturally.
An expert can come to the conclusion,
Wait,
my lord.
wait for a week before
Fine, no
demolishing.
problem.
Yes, your lord.
The registry that tag the file of writ appeal number
63 of 2023.
63/2023 with this appeal and list both the matters together on 23rd March.
Mine.
Interim order shall continue till next date.
Lordship. Obliged.
Deeply.
Item number 15.
Yes.
That OBC certificate. So the state was directed to file that affidavit, they filed it.
It is on record.
They have also brought on record the documents which we placed on the last occasion.
Okay. The service record of the mother of the girl.
Yes, yes.
That is in 280
And at serial number 120, it is clearly indicated that I am post OBC.
Let senior counsel come. Yes, please.
I'll require a little time because government affidavit shows in one of the documents is OBC. In another document is general. I don't know what cards they are playing.
They are not playing any cards. The record corresponds to the years 2004, 5.
But other
What cards can they play?
same Milord, the records from the government side. You say in a general.
Very well.
What is the locus standi of the appellant, my lord? I don't know, my lord.
Precisely, we are on that.
No,
Let us see their locus standi.
There can't be any question of
The same,
sadistic pleasure.
this question arose, my lord, before the Bombay High Court.
Yes.
Bombay High Court has decided the position, then any citizen can come. And Bombay High Court is relying on FX court decision, but the reference is not given. Anyway, your lordship will kindly give me 1 week's time. The government has to be specific about, they cannot rely on two
My lord,
documents.
can I make
Government-
one submission?
Government did not take any stance and it was on our direction that they have produced the contemporaneous record and which establishes beyond all manner of doubt that even the mother of the girl, she was an OBC candidate years back, her service record, that can't be changed now.
No, all along, right from the, even after appearing in the APSC, she took admission in the law college.
My lord, this certificate was obtained in the year 2006 when I was a child. It was never in my contemplation that I'll have to face a litigation. my lord.
Precisely.
And moreover, my lord, suppose for argument's sake, I admit, this ABC, is she entitled to reservation as OBC? Because nothing is mentioned about the creamy layer.
That is not the issue in this.
No,
Writ
that
petition,
may
sir.
not be an issue at that
Yes.
point of time, but this is a law point, my lord.
The creamy layer issue is not there. The selection of one candidate, you pick and choose and say that she was not a part of the creamy layer at that particular point of time. That's
that-
not done, sir.
Both government and the APSC.
This
they
is
have to decide
persecution
that
rather
point.
than a prosecution.
Anyway, let me,
Very well. Mr. Chaudhary, senior counsel
My
wants
lord,
time to
can I
prepare.
make one submission, my lord?
Yes.
Pursuant to the learned single judge's order, I am entitled to reinstatement. That is being held up.
Why?
Lord-
We'll make it clear that there
Yes,
is no
possible
stay.
make that clear. Let him take time.
Counsel, Mr. Bhattacharjee.
no, my lord, after hearing us, kindly do that.
No.
Sir, we have not passed any stay. We will make it
No,
clear on his
No,
request.
I'm told they have already gone to the single judge on this matter.
They will, of course. Why not? So we'll make it clear.
No,
Mr.
they have passed,
Bhattacharjee,
the single
it
judge
is
passed the
you.
court.
We are ready to decide the matter
Kindly
today, sir.
Kindly listen to me.
Yes,
They have gone to the single judge
yes,
and single judge passed that order, reinstated.
yes.
So why in this?
We'll make it, because you are in appeal. Many a times the government officials,
Yes.
they want to buy time.
Precisely
Matter is
that has
pending in the
happened.
appeal. Let us wait. Even in the contempt, that statement is made.
What I am saying, my lord, the learned single judge has dealt with the matter in another her writ petition. And there the learned single judge has already asked him to government to reinstate.
And my lord, because of the pendency of this writ appeal, my lord,
We will simply say
yes,
that there is no stay
yes.
because you are making a request. We'll clarify that there is no stay on the order of the learned single bench. The government counsel, government advocate has filed affidavit bringing on record facts referred to in the order dated 28/2/2023. Then senior counsel, Shri Bhattacharjee, representing the petition appellant, prays for time to prepare and argue the matter
No, to reply to that document also.
to and oblique or to file counter affidavit in reference to the state's affidavit. List up to 4 weeks. We make it clear that there is no stay on the order passed by Leonard Singh.
Item number 16.
May please, Lord.
Yeah. Yes.
May it please your Lordship, before my senior friend starts, Lordship, in this matter, we are appearing as for the General Administration Department. Our name has not been reflected, your Lordship, so actually we have missed the case.
The council, Mr. So-and-so, appearing for the GAD department, submits that the case could not be noted because his name was not reflected in the call list. Registry is directed to do the needful and list the matter after 1 week.
1 week. Obliged.
Matter number 17 and 18.
Lordship will recall that vendors in railway stations. And a similar matter in respect of a different railway station came up on 10th last Friday. And that has been disposed of, saying that the railways will decide, will be given an opportunity of hearing. That
Let us have the order.
Hmm?
46.
मन लगी वो कॉपी ना दे दे My lord, may kindly see paragraph 14 and 15, madam.
Yes, please.
May I read, madam?
Sure.
If the applicants pay all the area amounts at the enhanced rate, being the difference between the enhanced rate and the existing rate, the situation as of today would be as if the appellants had never approached the court. There was no interim order and they have readily agreed to pay the respondents the entire dues at the enhanced rate and they have actually paid it. If that is the situation, we now leave it to the respondent authorities in the respondent railways to take their decision as to what they would have done had the appellants paid the van fee for the entire period at the enhanced rate without raising any dispute, and accordingly, we also leave it at the discretion to do the needful as they would have done otherwise. In doing so, the appellants be also given an opportunity of hearing to arrive at an effective reasoned decision between the parties. Till any such reasoned decision is arrived at, the appellants be allowed to continue with the vending business, but with a clarification that the payments of van fees would be at the applicable enhanced rate for the interim period.
Ms. Chaudhary, what do you say?
Lordship, in fact, I was a party in this case.
My learned
Same order we can pass?
I cannot say otherwise.
Obviously. Then counsel, Mr. Majumdar, representing the writ appellant. Writ appellants submits that controversy raised in these appeals stands covered by the order dated 10/3/2023 passed by coordinate bench of this court in writ appeal number 87/2023 and thus, you don't have any objection, Mr. Saiwala? You were also there in the other matter.
Does not be.
Yes. And thus, the instant appeal, these two appeals may also be decided in light of the aforesaid order. Then at the PSJ, Shri Chaudhary, and appearing for the railways, and senior counsel, Shri Sahiwala, appearing for the private respondents,
Not private, not P.
respondent number 3,
IRCTC.
do not oppose this submission in view of the contentions noted here in above, the instant these two appeals are disposed of in light of the order dated 10/3/2023 without recording separate reasons.
Passed in writ appeal number 20.
Writ appeal number so and so 87/23.
This judgment is in between my, not wholly in my favor, not wholly in their.
Naturally, they have been given a right to reconsider your things, which were disposed of in the following terms. Reproduce the part of this judgment.
Out of it, I can.
Para 8 onwards. Para 8 to para 16. Reproduce in and above. In view, and lastly, in view of the discussion made here and above, and the judgment with the modifications indicated above in the judgment and order dated so and so, comma, the writ appeal is partly allowed. Writ appeals are partly allowed.
Deep. This way I can save the time of the court.
Thank you.
Matter number 19,
Deep.
May I please, your lord?
Yes, please.
My lord, this honorable court has already admitted the appeal on 22 to order by dated 22 to 2023. And
Yes. Therefore, the other side,
other side is the state, my lord, additional senior government advocate Assam,
Mr. M.
Mr.
Bhattacharjee.
M. Bhattacharjee.
By mistake, the appeal has not been admitted on the earlier date. We'll do it today. All right, admit. The respondents are duly represented, thus notices need not be issued. List for hearing in due course.
Matter.
matter number 20,
Item number 20, 27 to 32, they are of similar matter. Subject to what your lordship may say, my lord, I am totally.
In item number 20, notice is not issued. Lordship, I am appealing for private
For-
respondent, but another private respondent is there, lordship, private respondent 5.
He is connected with item number 28. He has
20.
filed a separate appeal.
He has
Yeah,
filed a writ appeal.
Great appeal, my lord.
28, Prasanta Sarma.
Yes.
Okay. Who is the
So
council representing?
What I am saying, my lord, subject to your, what your lordship will
Yes,
say.
please.
Page 126, may kindly be sir.
Of this item number 20.
Yes,
Okay. 126.
yes.
Yes,
Paragraph 36, my lord. It says, my lord, the settlement has to be given, my lord, may I read this, my lord, small
sure,
paragraph?
sure. Please carry on.
Under the aforesaid facts and circumstances, this court would left with no other option but to hold that the impugn orders of settlement dated so and so by which the bid of the petitioners have been ignored and that of the private respondents have been accepted are not sustainable in law and accordingly the same are set aside and quashed. Consequently, it is directed that the settlement of the various bazaars and parking stands under the Jorhat Municipal Board may be made with the valid highest bidder at the price offered by him. The said settlement has to be for the period which was mentioned in the NIT dated 23/6/22, which was for a period 1/8/22 to 31/3/23. We have no problem, either. However, since the settlement would commence from the later date, this same should be made for a period of 8 months. Already 8 months is given, it goes beyond the period of settlement mentioned in the NIT. So what I am saying, my lord, since this order has already been implemented because the order has been already issued. So this should not be a precedent in future because this goes contrary to the notice, my lord.
So you mean to say that this judgment should be restricted as having effect on the controversy in the present case only?
Yes.
Only this clarification you want.
Do, my lord, because otherwise the order has been implemented and my
For,
lord,
for a period of 8 months, the tender has been granted, the work has been granted to
it has
the
been granted
highest
by the-
bidder.
Yes, to the highest.
And accordingly, the market was settled with the private respondents and we have already deposited a case money. And
What
we
do you
are-
say? Any objection to this submission? We make it, this judgment applicable to the present controversy only. Will not have any precedential value. On the submissions,
As regards settlement beyond the period of settlement.
Learned
mentioned
counsel,
in the NIT.
Shri Das submits that as the order under challenge dated so and so has already been complied with, comma, a clarification may be made that this order will be restricted only to the controversy at hand because by effect of this order, comma, the settlement has been granted for a date beyond the period mentioned in the original NIT, which was 31/3/2023. Learned counsel representing the respondents do not object to the submission so made. Thus, comma, it is hereby clarified that the order dated so and so passed by learned single bench shall not form a precedent and will be considered as having effect on the controversy arising out of the NIT dated 23/6/2022 only.
This disposes, my lord, item number 27, 29, 30, 31, 32, 33.
With the above observations and modifications, comma, writ appeals number so and so are disposed of.
Well, item number 28 is filed by the private respondents.
Same order.
Private respondent. He is not here.
Mr. BK Das is not here. Call Mr. Das at 2. He may make a statement accordingly.
Obliged.
So this takes care of item number till item number 23. 33, sorry, 33.
27, 29, 30, 31, 32, and 33.
Okay. All pending
28,
applications, pending applications, if any, are also disposed of. So we will reassemble at 2.
Obliged.
Thank you. 28, someone has come.
Okay, we have informed him.
Okay. So he is not come. Is he in the court?
He quoted 39 lakhs, my lord, and the petitioner, the respondent quoted 68 lakhs.
Oh.
So therefore, highest tender was.
Yes, Mr. Counsel, what do you say?
My lord, here, my lord, we have challenged on the ground that, my lord, whether the fix that given in the NIT, my lord, page 44, fix that, my lord, it is for 1/8/2022, 31/3/2023, my lord. But my lord, by the impugned judgment, my lord, the honorable single judge, my lord, has exceeded that period, my lord, by saying that 168 of the my lord, appeal, the settlement has to be for the period which was mentioned in the NIT dated 23/6/2022, 168, my lord.
Yes.
Which was a period from 1/8/2022 to 31/3/2023.
We have already affirmed that order in the other appeals. What do you say?
My lord. My lord, but
You want to have a different stand, you are free to do so.
Which is, the object of submission has already been complied with.
My lord, if the my lord, municipality has given, then my lord, perhaps my lord, there is a restriction on my part also to make some submission on this. However, my lord, but our submission is that, my lord, while period of tender is fixed by the NIT, whether the London single judge could table beyond the terms of the NIT, my lord.
That is why the council for the municipality said that let it be operating or having an effect on this set of circumstances only, not to apply on future tender process. What do you say? We cover your case with by this order?
My lord.
Very well. So item number 28 also disposed of in same terms.
My lord, deeply obliged.
Item number 41 of supplementary list.
May it please your lordships. My lord, here is a fishery settlement was interfered with by the learned single judge, my lord. The settlement was for a period of 7 years. It was given on, my lord, 8th of March 21. Now it has been cancelled. If your lordship would kindly come to the settlement order at page 52, my lord. Why it was not given to the petitioner respondent? Please come to my lord.
Settlement would be just like a lease.
It's a lease.
It's a lease.
Lease. It's a statutory contract, my lord.
Understood.
because under proviso, under rule 12 of the fishery rule, it is being given. My lord will kindly come to page 52, serial number 2.
52 or 72?
52, my lord.
Yeah.
52.
Yes, please.
Serial number 2, that is the writ petitioner society. Now, in the settlement order, my lord, what are the shortcomings in the tender of the writ petitioner? That is being indicated. The society has offered bid value of 2 crore 62 lakhs and odd at the rate of so and so, which is highest. The fishing certificate, experience certificate is issued by fishery extension officer of the, instead of district fishery development officer Morigaon, in the name of the president of the society, and does not cover all the members of the society. The neighborhood certificate is issued by DFDO Morigaon, but concerned revenue circle officer is only competent to issue such certificate as per government circular dated 18/1/18. No attested resolution of the society authorizing the president to submit the tender is found with the tender. So these are the three infirmities which are noticed in the tender of the writ petitioner. My lord, serial number 4 is the appellant, my lord, who was settled with. The society has offered 1 crore 99 lakhs 85,000 for 7 years at the rate of so and so. All documents submitted with the tender are found to be in order. Now, my lord, there were as many as 12 tenders, my lord. If your lordship would now kindly come to page 53.
Yes.
Towards the bottom, the sentence starting it from the above. From the above, government is of the view, number 2, my lord, out of the total 12 bids, only 3 bids are found valid as per the documents reports submitted by tenders in terms of the NIT as shown below. Pakori Doba, that's the appellant, which has offered 1 crore 99 lakh 85,000 for 7 years, is the first highest valid, overall 5th highest, and members residing in the notified villages as per registration certificate are within 5 kilometer radius of the fishery as per neighborhood certificate. So, my lord, out of 12, only 3 were valid, and amongst the valid, I am the, my lord, highest bidder. Now, my lord, kindly come to that notification at page number 134.
What is the date of the settlement?
The date of settlement is, my lord, 8th of March 21.
You had started working.
Yes, my lord. Now it has been cancelled, my lord. Now, pursuant to the single judge's order, now I will be, my lord, I mean, ousted. Now, kindly come to this 134. 134, my lord.
Yes,
this is the notification which, according to the learned single judge, since it was not part of the tender, is not required to be followed. A lot of anomalies, discrepancies have been observed while verifying tender documents forwarded by Deputy Commissioner SDO pertaining to settlement of 60% government fishery by government in the fishery department. As a result, most of such settlements are challenged by aggrieved parties before the High Court. It is therefore felt that there is a need for streamlining the procedure for submission of information documents with the tenderer so that there is uniformity in all such tenders through notice inviting tenders floated by Deputy Commissioner to maintain transparency and avoid legal complications. Now, my lord, will kindly come to Roman number 1. Actual 100% actual fisherman certificate, submission of 100% actual fisherman certificate of Fishermen Cooperative Society, SHG, that is self-help group, NGO issued by ARCS, indicating all the members of the fishery cooperative societies. That means, my lord, fisherman certificate will be issued by the Eastern Register of Cooperative Society. Then, my lord, number 2, neighborhood certificate by concerned revenue circle officer. Then, my lord, fisherman experience certificate, number 3, to be issued by DFDO. Now, my lord, this was followed by the authority. So what was the fault committed by the authority, my lord? What the learned single judge, the view has taken is, in the comparative statement prepared by the Deputy Commissioner, no infirmity was noticed. What the normally Deputy Commissioner do, my lord, he just takes note of whatever is given and he forwards it. Because settling authority is the government. So Deputy Commissioner is not the settling authority. Now, my lord, will kindly come to the impugned order.
Yes.
At page 130. Para 22.
Yes.
There are apparently 3 grounds of rejection. It is, however, to be noted that the price bid of the said petitioner is found to be highest. The three grounds are that fishing certificate, experience certificate issued by fishery extension officer instead of DFDO in the name of the president of the society and does not cover all members of the society. Second ground is that neighborhood certificate issued by DFDO Morigaon and not by the revenue circle officer who is stated to be the competent authority as per government circular dated so and so. Thirdly, no attestation of resolution of the society in authorizing the president to submit the tender was found. In response to the said grounds, it is found that the first ground of rejection is squarely covered by the decision of this court in Maligarh. My lord, I have read the judgment, my lord. In the judgment, nowhere, my lord, there is reference to this circular. The judgment, some view was taken by the learned single judge, same learned single judge, my lord, but it was without reference to that notification of, my lord, 18-1-2018. Therefore, in my humble submission, the view is not correct. In other words, my lord, the impugned order has the effect of making that government circular issued under Article 162 to be odious. It will revive an illegal order. Now, come to the para 23. This court also finds force in the contention made behalf of the petitioner that NIT did not specify the authority to issue such certificate in any case, the fishery extension officer cannot be held to be incompetent to issue such a certificate. My lord, if a manner is prescribed, it has to be done in that manner. My lord, if your lordship would recollect the judgment of the Supreme Court in, my lord, Patel Engineering versus West Bengal State Electricity Board, best ways to confirm transparency is to stick to the tender conditions. The moment if the actions is in conformity with the tender condition, there's no question of any arbitrariness having been crept in.
Right.
Then my lord will kindly come to the third. As regards the Gazette notification dated 18-1-28, though certain doubts have been expressed by this court in case of Goripur Society regarding his application and also question of his application in the Gazette, the said notification is placed on record, which is in the form of a Gazette notification. The court is of the opinion that point will not act as a hurdle for this court to acknowledge the notification. However, more than its existence, what is to be decided is the applicability of the condition of the said notification in the tender process. Mr. Sharma Lanet State Council has strenuously argued that Gazette notification is of the year 2018 and NIT is of the year 2021, and therefore it cannot be assumed that all intending tenderers are not aware of the requirement of law. However, having taken into consideration, this court is also cannot ignore the condition of Gazette notification, which require that all ensuring tender process have to incorporate the conditions given in the Gazette notification, which admittedly has not been done. It is right law that while applying a notification, it cannot be done in a way that only—
Can we read this condition in the notification?
Yes,
That the terms shall be incorporated?
Yes, that is there, my lord.
Where it is?
Yes. Page number, my lord. 1 second, my lord. Page 134. At 135, it is there, my lord.
Let's see.
First of all, 134 itself.
34 itself.
My lord, it is bold in bold letters. Accordingly, it has been decided.
Included in the NIT.
That's all, yeah. Well, it was not done in this case, I admit, my lord. Now the issue is very simple, my lord. The learned single judge was deciding the decision-making process. Now, my lord, Deputy Commissioner has forwarded all the materials, including the comparative statement, and the settling authority took note of this circular of 18 January 2018. Now, if this circular prescribes a manner of doing a thing, it has to be done in that manner. And the lordship has seen there is no element of, my lord, arbitrariness in the decision-making process. All that the settling authority says is out of 12 tender, 3 have followed the complied with this circular, and out of the 3, my lord, the appellant before lordship, he is the highest valid bidder. Otherwise, he is the 5th highest bidder. Now, I don't think it was a case, my lord, where, my lord, the learned single judge interference was called for. Because my learned single judge was not taking a call on the merits of the decision, my lord. It was a decision-making process. Now, my lord, fact of the matter is today, till today, we have not handed over charge, my lord. We are still operating, but any day they might take over possession pursuant to the learned single judge's order. My humble submission is lordship will call for the records and examine the matter. Till then, my lord, lordship will maintain status quo in respect of possession of the fishery.
Yes, please.
I am for the respondent number 4, your lordship. Your lordship will kindly come to page 134 again.
Yes.
Now, your lordship, this is your lordship, the The clause, your lordship, 1, accordingly, it has been decided that the following clauses are to be included in the notice inviting tender for settlement of 60% of the tariff.
Okay.
Now, the moment, your lordship, it says,
Mr. Botakur,
lordship,
this is a gazette notification.
lordship,
Is ignorance of law a defense in this country?
no, your lordship will kindly note one aspect of the matter.
Your clients are people dealing in fisheries.
Lordship,
To presume that they will be unaware of this notification would be totally foolhardy.
no, your lordship will kindly note one aspect, your lordship. The moment, your lordship, it says, your lordship, that your lordship, these will have to be
Are to
included.
be included,
Are to be included.
shall included, and
No,
are to be.
your
Whether this
lordship-
is mandatory or directory, we will have to consider.
No, your
So for
lordship,
that matter, the
no, your
appeal
lordship.
merits
Your
consideration.
lordship will kindly note another aspect also. Your lordship.
Yes.
The fact remains, your lordship, I am offering your lordship.
Yes,
more-
that doesn't matter.
that-
We are not starting a bargaining process in
No,
this
your
court.
lordship will kindly see, your lordship, ultimately, when the authorities, your lordship, in the government, your lordship, apply this criteria is applied as a hidden criteria, your lordship.
Why it is it?
Because
Is
your
it
lordship, these are
not a
these are-
gazette? Have you questioned that this is not published in official gazette?
Lordship, so far as my submission still is that this is not published in official gazette, your lordship.
Let
That-
us see your pleading then.
Lordship.
Let us see your pleading.
Which your lordship.
They must have brought
what
it on record.
is-
Just hold
no,
on.
lordship,
Hold
what
on.
is- What is important?
Hold on, please. This must have been brought on record in
No,
the writ petition.
no, your lord. That's what. It was produced only before this honorable single judge as a document, your lordship, without any affidavit, your lordship. Till date, your lordship, we have not been provided with any copy.
Let us see state government's stand.
No, your
publication
lordship,
of the Gazette.
State government did not file any affidavit in my case.
We will see. We'll ask them whether this has been published in the Gazette or not. Yes.
To verify. The submission made by in the honorable chief
Because there is
justice
some doubt expressed even in the single bench order regarding publication. Let us have the Gazette notification, please. Original notification tomorrow,
Lordship, tomorrow.
list tomorrow. Learned Government Council to place on record the official Gazette notification of document annexure. It shall file an affidavit to satisfy the court that the notification dated 18th January 2018 was published in the official Gazette. List tomorrow. Day after tomorrow.
Till day after tomorrow, status quo be maintained.
Lordship is, since your lordship is taking up
No, no, what I'm saying,
Lordship.
anything can happen tomorrow.
Then you instruct your clients not to disturb the status quo.
Yes. Deeply.
Item number 42.
Deeply obliged.
Yes.
May it please your lordship. 42 and 43. I presume they follow that same railway vendors issue, whereby the right to vend was interfered with an observation, which fell, of course, out of course. And when not in the early hours, I was there in the court. There's some order passed by division bench, coordinate bench.
10th March. 10th March order.
10th March order.
Yes.
Perfectly, Lord.
Yes.
May I pass over the copy of the order?
So you want your appeal to be decided in same terms?
Same terms, my lord. That
What do you
was-
say?
So far, other things are concerned, nothing, my lord, because that order was in respect of minor vending. Minor vending.
Okay.
And here, one case is there, the case repression room, which is major vending, and there tender has been issued and tender was not stayed by the honorable court, my lord, I am just giving, and tender has been finalized at 5,04,000, madam.
I presume that would not be correct stand in accordance with the law. Lordship, if I may just open up my
Fact
submission.
remains that the tender has been finalized
Finalized, my lord.
and it has been affirmed, the action has been affirmed by this court. Then where's the question?
So far as finalization of tender is concerned, under the circular of 2017,
Yes.
it speaks about rather, e-tendering. Now the railway board in 2022 has come up with e-auction.
Yes.
E-auction is quite different from e-tendering. So tendering any format would not have been proceeded with.
Could not have been proceeded with as a different thing.
I understand.
It has been,
It has
and
been.
it has been affirmed by the single bench.
Yes.
Tender would not be, in this case is concerned, I presume tender would not have been finalized, Mullah, because so far as our petition was concerned, that was only
Is
to
it
the
writ
extent,
filed by you? Single bench matter?
single page
Yes,
matter
yes.
is one of the petitioners, yes.
One of them.
Insofar as the writ petition was concerned,
Yes.
we had raised a challenge twofold.
Yes.
That the demand notices issued by you was something which percolated from the IRCTC, sent to us by the railways.
Mm.
We disputed on 2 counts, we had never worked under them, and it was arbitrarily high. Eventually, there were stay orders by this honorable court, we continued to swing.
Now, the stand of the responding authorities on record was that it is not that we would not renew, rather we would renew if you pay. That is the stand. In these circumstances, when the batch of petitions came, somewhere there was affidavit, somewhere there was no affidavit.
Yes.
Eventually, the honorable single judge interfered with the notices and set them aside. However, holding that, they have a right to realize the fee at the rate of 10% or whatever. And if you pay, then only, but a right to vend was interfered with. The interference with right to vend is the only crux where we are before this honorable division bench of this honorable court. We're not on payment or no, we'll pay. Now, there's a coordinate-based judgment saying that.
But what Mr. Saiwala
I
says
understand.
is that for the major vend, they already issued a tender
My lord,
and they finalized the process.
very well.
So that
But if
finalized
I-
process is not in challenge in this appeal.
That could not have been, Milord, because
Yes.
this is only to that. But if I may just pay out, Diana, if we just pay out, Milord, so far as 2017 circular is concerned, it's there in the annexures, I'm not taking out.
Yes.
Talks about e-tendering. But
Yes.
e-tendering would be something when I tender by way of the internet medium.
Yes.
But now, look here. But now, so far as the 9th September 22 is concerned, this is by the same railway board.
Yes.
It talks about the next page. It's about e-auction. The
Hmm.
e-auction is when in a web page we bid live.
Bid live. Yes.
Bid live, we
Yes.
bid live. It's quite distinct and different from e-tendering. So if they have adopted a procedure alien to what they hold the field,
Okay.
possibly will stand in a court of law. But till then, my protection, that inequity, under the equitable consideration,
Mhm.
if lordship protects me, then
Yes.
it's fall in the same line. Maybe due to paucity of time or my, I do not have the information, what they did or what they did not. It's just now I could come to learn, finalize.
Just complete your instructions, then get back to the court after 2 days or so.
Certainly, we would file, we would certainly file.
Yes.
As of now, if they go ahead with that, regardless of the fact it's not in the challenge,
Gentlemen, if the tender has been finalized and awarded, contract
We'll
has been
challenge.
awarded to someone,
we'll challenge.
can we
No,
do
we
it
have to
without?
challenge.
hearing
So
that
far as
person?
the refreshment room is concerned, that option may be given, I leave it to your lordship.
Option of what?
Liberty to challenge, because I could learn now, right now,
Yes.
that right be crystallized,
Okay.
that fortification, obliged.
Yes, my lord. Because other things are minor vendors, my lord, that will cover.
Okay. So far as the refreshment room
Yes.
in the major event is
That one, yeah.
concerned,
That one, yeah.
your statement is that the contract has been awarded or
The
not?
contract, once they finalize, they will issue the LOA.
They will be issuing the work order.
Yes, they will be issuing, my lord. So,
Okay, very well. मॉर्निंग में जो लिखा है था ना उसमें ऐड कर दीजिए as an exception, comma, Shri Saiwala pointed out that the petitioners, which is the petitioner who is claiming the
Item 42.
major vend,
Holodhar Kolita, item number 42.
read the my lord.
petitioner number so and so, petitioner so and so is having a major vend for which, comma, a fresh tender process was initiated and has been finalized in view of this submission noted above, comma, leaving the said petitioner at liberty to challenge the tender process referred to supra by availing the appropriate remedy, comma, the writ petition is disposed of.
My lord, that may mention a refreshment room at Rangia.
Refreshment room at
Rangia.
so and so.
I just pray for the word only prior to refreshment room, because I have tea stall and dala also.
Only.
Only.
Only. Refreshment room only.
43 the same, they're minor.
43 same.
Same. Grateful, lordship.
43 would be covered by the order passed in morning. Yes.
I'm grateful, Milord.
I'll clarify that. Chairman.
Item number 21 of daily list.
21. It's a passed over matter. Orders. Okay.
Lordship, so far the issue involved in this case, SLP is pending before the Honorable Apex Court.
Okay.
So this matter may come up after 3 months.
Okay. Then counsel. You are Mr. Borboya.
L Mohan.
L Borboya.
L Mohan. L Mohan.
L.
Mohan.
L Mohan. Okay. Mr. L Mohan, then counsel for the appellant states that the matter pending before the Apex Court has still not been decided in view of the submission made here and above, comma. The matter, the instant writ appeal, consideration of the writ appeal is deferred by 10 weeks, awaiting the outcome of the matter pending before Supreme Court.
Item number 22. 22 is the infraction.
In fact, Lordship, by the last order, I was directed to take steps. However, he says that it has become infractious. Lordship, can it be in the next week? I'll take the instruction.
Why it has been rendered infractious?
My lord,
please,
it
that
is
is-
a transfer matter, tribunal against the order of the CIT Guwahati bench, the union preferred this writ petition.
Okay,
So in the meantime, he was transferred from Guwahati to Calcutta. He is an employee of the Debt Recovery Tribunal Guwahati.
okay,
He was transferred from Guwahati to Kolkata. After serving there for about 6 months, he has been returned back to Guwahati again. So issue.
on his statement, we'll do that.
Lordship,
Okay.
Lordship.
The instant writ petition is preferred to challenge the order dated so and so passed by CAT Guwahati bench, whereby, the transfer order of the respondent, a LDC serving in the railways from Guwahati to Kolkata
Right.
was interfered with. Land counsel, Shri so and so appearing for the respondent states that during pendency of the writ petition, the respondents have cancelled the transfer order
That has been, because he has been returned back, that is infractions.
to
To Guwahati again.
the respondents have themselves, the authorities have themselves
Yes.
passed an order transferring the respondent back from Kolkata to Guwahati. In view of the submission noted above, nothing survives for consideration of the court in this writ petition, which is disposed of as infructuous.
Acknowledgement.
Item number 23.
Lordship,
Against this matter, the SLP is still pending, Lordship.
Okay.
So I've created
status
matter-
order has been passed there.
Okay,
created matter may be pending to be mentioned by either of the parties on disposal by the of SLP.
it is stated that the matter issue pending before Honorable Apex Court has still not been decided. Thus, the instant contempt petition is disposed of, is deferred by 10 weeks.
Much obliged.
Item number 24.
List of 10 weeks. Yes.
May it please your Lordship. Lordship, in this case, Lordship, contempt has been alleged against non-payment of the compensation, Lordship, that have awarded by this honorable court, Lordship. In the meantime, the respondent authorities had gone up to the Supreme Court and the Supreme Court had dismissed the SLP in January this year, Lordship. Now the status is, Lordship, the army headquarters has already cleared it, Lordship. It is with the ministry. It should be cleared within a period of 4 weeks, Lordship, the payment.
Okay. Deputy SJ, Mr. Chaudhary submits that the order under contempt dated so and so shall be complied with in the letter and spirit within next 4 weeks.
Lordship.
List on 26th April. Okay.
Item number 25.
In statement, submit that SLP preferred against the impugned order has been dismissed and as a consequence, the order under contempt so and so shall be complied with and so and so. Yes,
In item 25, my lord, I prefer 1 week time, my lord, for filing the affidavit, my lord.
for filing
Filing of the affidavit for respondent number 1 and 2, my lord.
and counsel. You are Mr. D Nath,
I'm Dina.
senior government advocate, praised for and is granted further opportunity of 2 weeks to file the counter affidavit.
My lord. Lordship.
Much obliged.
List up to 2 weeks.
Item number 26.
So it's 25. What about in 23? 10 weeks, okay. Yes,
May I please your Lordship?
yes, please.
Yes, Lordship. That is a Government of India has passed a circular dated 23rd of April 2018.
Mhm.
It is a publicity scheme, namely known as Benami Transaction Information and Reward Scheme.
Mhm.
2018 for informing the public in general that reward would be given for giving information of Benami property accountable under a Benami transaction. 2018, followed by a press release dated 12th January, which is an extra 5, Your Lordship.
Yes.
In an extra 5, that is, Your Lordship, in this press release, a scheme was announced regarding a e-portal website is there. Any complainant
Gentlemen,
can
read
file-
your prayer, please. You want us to issue a direction to the income tax department to follow the law.
No, Your
Right.
Lordship.
Read the prayer,
It is-
please.
My prayer is, Your
Read the
Lordship,
prayer, please. As vague as it can get. Brother, read page 34. Read, sir, for our benefit, please read out.
in the premises aforesaid, it is therefore respectfully prayed that Your Lordship may be pleased to issue rule, call for the entire records, and issue a rule calling upon the and to show cause as to why the writ in the respondents' nature of mandamus or contrary or any other writ should be issued to the respondents' authorities, thereby directing them for strict adherence to the prevailing laws under the Income Tax Act and other related laws and schemes, and also take stringent action against all persons who are responsible for implementation and following of the same, but have remained silent and or have themselves violated the prevailing laws, and upon pausing the causes shown and hearing the parties, be pleased to make the rule absolute and directing them for strict adherence to the prevailing laws under the Income Tax Act and under other related laws and schemes, and also take stringent action against such persons who are responsible in implementation.
In substance, what is the gist
My-
of your prayer, please?
My gist of the prayer, Your Lordship, there are certain high value transactions which are taking place before the sub-registrar. The information which they are supposed to sub-register is supposed to provide all high value transaction to the income tax department. This information is not being forwarded to the income tax department as per the rules 114 of the income tax rules, Your Lordship.
What is the bona fide of the petitioner in filing this PIL?
Your Lordship, a large scale tax evasion is taking place. By which the government
So
is
to
losing.
test your bona fides, we require you to deposit peremptory cost of rupees 1 lakh. Okay, before issuing notice on the writ petition, we want to test your client's bona fides. Is your client prepared? Take instructions.
Yes, Your Lordship.
Very well. In order to verify the bona fides of the petitioner, this court proposes to require the petitioner to deposit peremptory cost to the tune of rupees 1 lakh. Counsel for the petitioner and counsel Shri So prays for time to complete his instructions. List on 23rd March.
The number 34.
May I please, Your Lordship? My lord, service upon the respondent number 7 awaited, Lordship.
You want time to effect service?
I already taken steps,
Okay,
Lordship.
then counsel states that he has already taken steps for effecting service on the respondent number 7.
Yes, Lord.
Await return of notice for a week.
Interim is their Lordship.
Interim order shall continue till next date. List after 1 week.
All right.
The number 35.
May it please your lordship.
Yes.
My lord, this is condonation of delay of 41 days. My lord, they have filed an objection, my lord.
Right.
Only difficulty we are facing is that, my lord, already the sole respondent, he has already filed contempt petition before the learned single judge after filing of the writ appeal, in fact, my lord. So if
What do
they
you say
don't-
to condonation?
Lordship, we are appearing on behalf of the opposite party number one, Lordship.
Yes.
Secondly, Lordship, the contention of the other side's counsel, Lordship, is that it only came to our notice that the writ appeal has been filed against us once we had filed a contempt petition, Lordship. So we are purely bona fide on the respect, Lordship. Second, Lordship, we filed an objection to that, Lordship. That may kindly come on record, Lordship. We fix it after 2 weeks, your Lordship.
Then you don't press your contempt petition. If you want us to defer this IA, don't press your contempt petition till then.
After a week, your Lordship.
What is the problem, gentlemen? 41 days. Someday you will be standing this side, making a request for the condonation delay of 41 days. You want the court to take a consistent view,
Then,
not
Lordship,
to
may
condone
kindly-
delay?
Lordship, then this may kindly come on record, Lordship. We'll fix it next week, your Lordship. Our objection may kindly be put on record, your Lordship.
Likhiye, Land Council, Shri so and so, representing the respondent submits that he has filed an objection to the application for condonation of delay. The same be brought on record, list on 22nd.
Lord, in the meantime, the contempt.
When is that matter coming up?
My lord, no date has been fixed, my lord,
Lordship, is notice, Lordship.
but
Notice has
notice
been-
was issued on.
We record your statement that you will not press for the contempt.
Lordship, that.
All right, you call his objection right now.
Lordship.
Pass on your copy.
Yes,
We'll read
I
it.
have a copy, my lord.
Yeah, okay. Chief Postmaster General, yes, okay, very well. Your objections noted, delay condoned.
My lord. The writ appeal may be, my lord, the writ appeal may be numbered and
The
listed.
appeal, the register the writ appeal and list the same for admission on
Lord. Can it be
21st,
this Friday, my lord, if possible?
21st.
21st.
Once your appeal is numbered,
Yes,
the contempt petition will not be taken up.
my lord, highly honored.
Yeah.
Deeply honored.
Item number 36,
Yes,
May I please your lordship? This appeal is preferred by the state lordship and there is a delay of 15 days.
No objection.
no objection. The interlocutory application number so and so has been filed, seeking condonation of delay of 15 days in filing of the appeal.
And yes,
The Land Council representing the respondents does not object to the delay being condoned, considering the grounds set out in the application under section 5 of the Limitation Act to be germane, the delay is condoned, the application is accepted, registered to number the connected appeal, writ appeal, and list the same in court after a week.
much obliged.
item number 37,
May please your lordship. Lord, I am appearing on behalf of the respondent number 6.
Respondent is 6, yes.
We have filed a IA, my lord, praying for fixing the case date for hearing, my lord.
Okay. Your application is for early listing.
Yes, my lord, for hearing, my lord, early hearing. 4/8/2020.
Yes. What does the other side say?
We have no objection. Lord.
You are for the other respondents.
Yes.
Who is for the appellant? Have you served a copy on the appellant's counsel?
Yes, I am.
You are for the appellant.
Yes, Lord.
IA number so and so has been filed by Land Council, Mr. So and so, representing the respondent number
6, my lord.
6 for listing with a prayer for listing the appeal for hearing. Council representing the other side other parties do not object. Thus, let the writ appeal be listed for hearing in the month of May 2023.
May I pay for a date?
16th May.
Deeply obliged, Lord, sir.
Item number 38,
We have already decided similar matters.
Your lordship,
Yes,
lordship, in this matter, there has been a delay of 26 days in filing. the
46,
26.
26.
Lordship, in similar matter,
Delay kanon, we'd given the order about days 26. kar dijiye. Okay. The appeal, writ appeal to be numbered and listed in court after a week. Your delay application condonation is accepted.
lordship, item number 39 is also seen.
39,
British.
39,
26 days. 26 days. Deal.
26 days in this one and 39 same delay.
Yes, lord.
What do you say? Delay kanon, writ appeal to be numbered and listed in the court after a week.
Similar appeals are pending, my lord. Against the comment.
You give the numbers?
My lord, next step, my lord.
Okay, very well.
item number 40,
38. 38 and 39 are similar. Yes,
May I please, the Lordship? Lordship, we are selling the order of a single judge. There is a delay, my lord, 19 days.
19.
19.
The other side,
Other side, though, my lord, we have to take notices.
okay, issue notice of the interlocutory application number so and so to the respondents.
Dusty, my
Dusty
lord,
service is permitted, rule is made returnable in 3 weeks,
my lord, short date, my lord, because
2 weeks.
my lord, a limited prior, I don't know how the Lordship will entertain. There was an compliance of the order by us for within 6 weeks of the date of the.
Well, if you have been sleeping, we can't
No, no,
pass
my
an
lord.
interim order in an appeal which is not numbered.
Much obliged.
That's done. Thank you.